So sorry, we were all late in sitting in court because, today we dedicated the new creche. There's such a large number of young men and women lawyers. The earlier creche was about 200 square meters, which could accommodate about 30 children. Now we have 450 square meter creche, which accommodates close to 100 children, for our staff and for the members of the bar.
And the children do come.
Oh, it's packed. In fact, we have constantly requests. Now my child is turned 6. Can I have an extension for 4 months because before the child? So for those of you members of the bar, you may not have children, or as in the case of the solicitor, you have a grandchild, but please do go and see the creche. It's in the additional buildings, administrative buildings complex. It's a beautiful creche facility.
So beautiful that you might want to yourself stay there.
I'm waiting for the moment when some honorable judge says that you are too childish in your arguments. That makes me eligible to go there. But, my lord, we can do one thing, my lord. We can, my lord, I will not use, donate is not the correct word. We can contribute by giving toys or something, my lord.
We have in that creche, we have a play area for the children. The entire area is lined up with cushions so the child shouldn't, it's child friendly. Bathrooms have been redesigned for little children, including for changing rooms for changing babies' nappies. Then we have, apart from a play area, a dining area for the children, a feeding area for young mothers where you can feed your child in privacy. And there's a sleeping area for the children also. So the child there's a completely quiet area where children can sleep during the day, so on and so forth. So especially for, I always say it's not just a mother's thing, it's a father's thing as well. So all young lawyers would like to go and see it. Please go and see it during the course of the day.
Will make it a point to go and
we'll be happy to see the. And of course, we also unveiled today the new branch of the Bank of Maharashtra in the administrative buildings complex. So for the benefit of the lawyers, and it's a high-tech branch where we have automated lockers, all the other facilities, including wealth management, so on and so forth. So the prosperity of the lawyers should be reflected in equal financial services to them.
Yes, sir.
Some of the financial services that were explained by the branch manager and the chairman, I thought would mostly be intended for the professionals in the field, not for the judges.
Not till the honorable judges retire, my lords. But lockers for lawyers for professional services may not be a good idea. Lords, I'm obliged, lords. Lord, I'll, my lord,
yes.
Just highlight, my lord, what I would be, my lord, assisting your lordship with. Lord, the first principle.
Mr. Solicitor, we'll of course go by a very heartening and fair statement yesterday that you will not take as much time as was reflected in the statement. We have seen your written submission, which are comprehensive actually.
I stand by that. From there also, whatever my learned friends have already drawn your lordship's attention to, I'll skip. And my lord, my broad roadmap, my lord, for assisting your lordship is this. Lord, arbitration has necessarily its roots in the contract. And contract by necessary definition is an act of volition.
One second. The contract is a
act of volition by definition.
I know, but equally, we know the other flip side. Say somebody who wants to be a contractor with railways does not really have a negotiating capacity. Either you accept the contract.
I have an answer to that. My submission.
It is an act of volition. So you agreed to this arbitration clause. How can you complain of the arbitration clause?
No.
At the same time, you must also we see both the sides.
Certainly.
But there's not that element of volition. If I want to sort of supply bitumen for the construction of a road, and I'm a small petty contractor, I have no negotiating power.
The standard form contracts, that
I usually clause 64, I leave clause 64, or I leave the contract.
Correct. Your lordships, as custodian of fundamental rights, would look into it. But I'm just starting my arguments. Lord, your lordships, at the end of it may perhaps be satisfied that the system which I have envisaged within the framework of law may,
good system.
Lord, meet with your lordship's concerns and, my lord, may achieve the object for which the act is enacted.
All right. So that first
Lord,
point is.
second, Lord, party autonomy is ingrained in the entire architecture of the act.
Yes,
No, my lord, and,
that's your argument being transcribed.
yeah, yes. In the entire architecture of the act, my lord, that's the submission. Third, third, Lord, unwittingly the respondents, Lord, who began the arguments, Lord, were trying to find out whether there is any permissive provision which provides for a neutral panel. Lord, my respectful submission is the question is wrong and therefore we are not getting an answer. The question should be whether there is any restriction which prohibits the panel which I am going to analyze, my lord. The panel also must satisfy your lordship's conscience.
Now, just for a little clarification, you say the panel which I'm going to suggest, you would be making that statement on behalf of the Union of India as an entity or how? Because
Yes, but I'm not suggesting on my own.
Right.
I own, my lord, what I'm arguing on behalf of Union Railway, Central Railway Organization is the petitioner. So for petitioner also, my lord, that's not, my lord, the point. My lord, it is to be found in the act itself.
oh, then there is. Yes.
Lord, why this exercise is necessary? Because, my lord, I'm not going individually to Perkins or any other judgment leading to Tatia, my lord. That's not relevant because your lordships are in a 5-judge combination. We address your lordships on principles and my lords would examine on principles. But somewhere down the line, my lord, there is a concept that this kind of panel does not give them the choice and therefore panel is impermissible. This is my paraphrasing. The wordings of the judgment may be wrong, may be different, but this is, my lord, broadly, few judgments have taken them. And that is, my lord, a valid concern that they must also have a choice. But please, my lord, kindly bear in mind, this is, my lord, an alternative dispute redressal mechanism. The parties contract that instead of going into the normal conventional litigation, we would customize our dispute resolution mechanism. Lord, the objection necessarily presuppose that the panel is controlled by one party and therefore we do not have much of a choice when there is a provision which misses the distinction between Which misses the distinction between a panel being maintained and panel being controlled. I can maintain a panel of neutral and impartial arbitrators without in any way controlling it.
Panel maintained and
Controlled. That is the distinction. They argue that this panel is controlled by you. My respectful submission is that the panel is maintained by me, not controlled by me. Your lordships are aware, my lord, depending upon the nature of activity of that particular contract, there can be, my lord, a panel involving honorable judges, it can be structural engineers, it can be architects, it can be civil engineers, it can be chartered accountants, everyone.
You're right, actually, solicitor, because their argument was that my objection, according to them, their
Yes.
objection is that this panel is controlled by the authority, by railways or by bail or whoever else.
Lord,
But then you'll have to, in your option, which you explore before us, you'll have to tell us how would you ensure that that control element is
exactly. Lord,
obvious.
I'm grateful for that. Lord, that is where the judgment in DMRC, Lord, I say DMRC because Voestalpine, my lord, just for
Voestalpine.
easy pronunciation, I say DMRC. Lord, what they say that your panel should be broad-based panel, having no having, my lord, various people from various facets of life, depending upon the organization which is making the panel. And that judgment is fortunately not disputed by anyone. That judgment says that panel per se, if it is contractually so provided, is not something impermissible. But you cannot have a panel of, say, 20 people, choose any one of them.
Except that Mr. Call, in the latter part of his submission yesterday, said that, look, while I accept the broad Voestalpine principle, this part, which says that so long as you constitute a broad-based panel, that is valid. He says that he has assailed in his submission, because I just looked at my notes.
Otherwise, my lord, kindly see the flip side of the argument.
Because, to paraphrase what Mr. Call argued, he says Voestalpine recognizes the principle of a broad-based panel. And the submission is that the objection is that the panel cannot be unilateral. To the extent that Voestalpine allows it, he says Voestalpine needs to be modified or reconsidered. That was squarely placed there.
To that extent, my lord, there is a divergence, my lord. They are not accepting.
Finding me to the panel. Thank you very much.
Lord, the other side has argued one extreme, that whatever the one side does is unilateral and therefore necessarily not impartial or would otherwise be objected to. But the flip side is, if that is not accepted, then you are free to choose your arbitrator, which may have some issues of impartiality and neutrality. And when I say impartiality and neutrality, I also include integrity.
But then, that will apply to you also. That's the point.
Correct.
Because
Therefore, I have an answer.
What Anirudh argued yesterday, in the latter part of the submission was that you may have a situation where the arbitrator who is on your panel perfectly fulfills the Schedule 7 requirements. And since you are approaching it in a very balanced way, we are really putting it to you. So
Yes,
you can find a solution for us as SG. So Anirudh argued that, look, the arbitrator on your panel, nobody will breach the 7 schedule requirement. But apart from the objection that this is a unilateral panel, he said there must be one more thing. Take a concrete case, he says, where that person has already done one arbitration in a period of 3 years. You constitute a panel so as to appoint only those people who have already ruled.
Incentive that.
That interpretation of, say, clause 36 of the general conditions of contract.
Correct.
Second, he says after the lapse of that 3-year time period, when the cooling off period is over, the organization can look at what is the track record of this arbitrator. Has that arbitrator been particularly helpful from an institutional perspective for us? We're not saying it is fraudulent on your part to do that, but this is natural. This is natural on the part of any organization. So therefore, the objection that, this may not necessarily result, a broad-based panel may not be an adequate formulation, because within that broad-based panel, there may be some problems which will never come to light otherwise. That's it. How do we
Yes.
answer that in the scheme which you are creating for us?
The way, my lord,
Does Rishikesh Roy say, does it hit the equality principle then?
Lord, I'll come to that. My lord, there is
Little
some,
later I can-
some confusion. My lord, equality principle has a different connotation under the act. My lord, I take your lordships to
You
some
can go in your own way.
a scheme
So,
provision.
last
Scheme of
point
the.
that I've
But my lord,
noted
let
is
me put
Boston
it.
Pine holds that the panel should be broad-based, having people from various facets of life.
Yeah, yes. My lord, ultimately, I'll say this last, but
And you're
I'll
supporting that part of Boston Pine, right?
That-
You're supporting that Boston Pine principle, I take it, that the panel should be broad-based?
Yes. My lord, adding something into it.
All right.
Because ultimately, as a government, we are also interested in ensuring that the arbitration as an alternative dispute mechanism grows, it furthers, and whatever are the hindrances or whatever are, my lord, what is preventing people from going into arbitration, especially the government agencies, is taken care of, and therefore I'm adding something.
Absolutely. And one perspective which government must also bear in mind is that if we are now today in an economy where we feel that private investment is crucial for the growth of the
Correct,
nation.
my lord. Government is
The
concerned.
nation. Therefore, from a broader national perspective of the government, it may be the interest of one PSU to rig the arbitration. We're not saying that they do it, but I'm just telling you. But from the wider perspective of the government as a nation state, there is a vital public interest or national interest in ensuring that the process of arbitration is fair.
Absolutely.
One element in that is, of course, huge public revenues are involved. If you get an award for 20,000 crores, it's part of the public revenues pay for it. Equally, government as a nation, representing the nation, has to be concerned with the fact that you must have the faith of the private sector in the arbitration process.
Who will invest.
To invest.
Yes.
And this is not just foreign investors, but domestic investors also.
Correct.
Right? So there is, in that sense, there's a governmental interest in both sides.
And public interest, that means public interest.
Governmental interest is not here only in getting favorable outcomes in the arbitration. That may be the interest of, say, ONGC, bail,
No,
particular
I understand.
contract.
No, I'm not taking it
Government's
from that.
interest is on a much broader perspective, which
I
we
have
must bear in mind.
not examined this from that myopic point of view. But I'll be very candid with your lordships, my lord, while being careful about the expressions I use. My lord, sometimes the system which we are following, that there is one arbitrator appointed by the government, PSU, or any other, my lord, a public sector body, and a private body. Sometimes, my lord, because of lack of neutrality, which includes integrity, we do not have a level playing field. I'll use my expressions, my lord, very cautiously, my lord, and I know, my lord, I'm able to convey, my lord, what I'm. Therefore, my lord, my panel, my lord, which I am improving upon, my lord, DMRC judgment is, A, they have a right to say that this is a tailor-made panel. To defeat them is a valid concern. To obviate that,
Can you just say that again, Solicitor?
Lord, the panel should not only be broad-based, but these are the criteria which your lordships may consider while improving upon what DMRC has said. Well, I'm sorry, but I forget the first name, therefore I'm, for my easy reference, using it at DMRC judgment.
Say should have additional safeguards
Yes, my lord.
over and above Wasselpine.
Yes.
Like,
Lord, first, the preparation of the panel must be open to all and transparent.
Just to, panel preparation should be transparent, not vis-a-vis a particular case, but generally.
Generally, yes. And when I say open and transparent, I mean, I will give an example, my lord, of say Ministry of Urban Development and Urban Housing. They issue an advertisement that we are preparing a panel of engineers. These are the qualifying criteria. These are eligibility criteria. You must ensure that there are no vigilance angles, because engineers are always, my lord, having some vigilance angles sometimes. You are not having any vigilance angles, just to ensure the integrity of the individual, etc., etc.
This is very important. So first was preparation of panel must be open to all and transparent. Two, I've said it two, the process. And then in two, I've said process. A, issuance of an advertisement, laying down the parameters for
Anyone can apply for being included in the panel.
panel. Issuance of an advertisement, laying down parameters, whether Roy said, laying down parameters for empanelment.
Yes, my lord. And anyone can apply who is qualified as per the panel. So that, my lord, we can decide, at least from our internal inquiries, etc., about the reputation, about the integrity issues. But this is not, my lord, very difficult to gather. So there is some, my lord, check. Otherwise, there is no check. Lord, but the expressions which are used in, my lord, in the arbitration field, I'll not use those expressions.
Again, just don't answer it immediately, because you're going in a systematic way. Suppose 15 years down the line, Mr. Call says, well, I want to now be an arbitrator. Would you expect him to apply for empanelment? How do you deal with that issue?
That
The best will never apply for empanelment.
my lord, in international field, my lord, even eminent people, as eminent as Mr. Call, my lord, may send the details. I'll apply, my lord, may perhaps not be a correct word, but may send the details. Somebody else can send his details on his behalf. My lord, an option for invitation can also be, my lord, kept open. There is no, my lord, we are not trying to make a tailor-made panel.
See, I'll tell you, you're right. Calling for applications promotes transparency. All right. But I'll tell you a little bit of my experience, because I've been now chairing the selection committees for appointing chairs of tribunals, national tribunals in India. Right, whether it's the National Green Tribunal, the National Company Law Appellate Tribunal. So many of my colleagues sit on these tribunals.
Okay.
The moment we circulate an advertisement for application, best judges don't apply. They say, if I'm good enough, take me. Why should I subject to myself to more eminent professional? They'll not apply. Now, therefore, what we have, your government has found a solution to it. The government calls it a search cum selection committee. So very often when I say I sit with the Secretary Ministry of Finance, Secretary Department of Personnel and Training, these are usually the secretaries who come, right? Or Secretary Consumer Affairs.
Justice or whichever is the.
Right. They normally say that, sir, we will open it out for advertisement, but it's a search cum selection committee. So they always tell us that you have the overriding power to also give us names of people who will not otherwise apply. Now, that assumes a degree of good faith, right? So if I'm sitting there, there's a degree of good faith that the Chief Justice of India is sitting on the panel. Or say, I very often depute my colleagues, that Justice Rishikesh Roy is sitting there. that we are feeling on the part of the secretary that if Brother Roy is recommending somebody, Brother Narasimha recommends somebody, it's bound to be good people above board. And after, of course, the IB process and everything is, their track records are verified by the Intelligence Bureau. But this is okay, you know, when you have people who are at this level. What happens, suppose the railways are constituting a panel? Who will take that decision on whom to induct in the
I'll
panel?
answer that
It
question.
will be ultimately a general manager in railways. At what level will that decision be made? Will it be the chairman of the railway board?
But that is the highest
So,
decision.
you know, the devil lies in the fine print.
Lord, Lord, that perhaps Lord, the minute nitty-gritties can be gone into only by the legislature. But
Well,
I
in
have
fact, just 1 second, I might forget it. We were just in our
then, yeah,
discussion.
please, Your Lord. Please, Your Lord.
Only because it might slip our mind. Point from Brother Rishikesh Roy, will this be a panel? It should not be a panel then confined only to one undertaking. For instance, is it possible for the union government to say that, well, we are preparing a panel cross undertakings because we have large number of PSUs, Navratnas, non-Navratnas. This is a panel, we will do the exercise at the level of what, maybe the level of the cabinet secretary to the government of India, because you are dealing with thousands of crores, if not lakhs of crores, that we will do this exercise across our public sector undertakings, and we will review the panels on a yearly basis. You can have, suppose there's a secretariat where you are reviewing the track record, any adverse complaints about the conduct of an arbitrator, so on and so forth. So we have to also factor in that arbitration has got sometimes a very bad name. We have wonderful arbitrators. We have some amazing arbitrators, but we also have both ends of the spectrum today.
That's the concern of, second is the concern of.
Would you be therefore contemplating a situation where Government of India prepares a panel for all undertakings of the Government of India, which will include your coal fields, will include your railways, or will it operate at a ministerial level? So Ministry of Coal will have a panel, Ministry of Finance will have a panel, Ministry of whatever, Corporate Affairs will have a panel. That will be again unworkable.
Yes, sir. My Lord, my answer is, my Lord, very clear. My personal answer is yes. I'll take instructions. I don't see any problem. Why? My Lord, I'm confident that I may not have any problem. Your Lordships are aware, and my Lords, all of you, Lordships, must have come across. There are certain things which are applicable to everyone. For example, public procurement. The Government of India makes the policy which is binding on all public sector undertakings. That this is how you will have to procure goods, services, etc.
Just see how complex it's going to become. And that's something which Justice Pardiwala mentioned just a minute ago. Take the case of Food Corporation of India. Take the case of Western Coalfields. Food Corporation of India has a pan-India presence. You have contracts for transportation, contracts for godowns, for which you are awarding tenders which have arbitration clauses. Now, if we were to contemplate a situation where the government of India were to do this exercise, the task would be gigantic, because you will have contracts from 10 crores to 10,000 crores
Sir, and 10 lakhs,
and 10 lakhs.
10 lakhs also. My lord,
Value based also.
value based and the eligibility based. For example, for some, we need only engineers. For some, where there are questions of law, we need judicial mind.
Are we walking into a minefield?
We are, yes, slowly and steadily, basically, the writ bar, we are effacing the distinction between public law and private law. Today's discussions and much of yesterday's distinctions seem to be how to bring in transparency in public dealings. That is what public law does. Administrative law is what it does. But this is in the realm of a private
Yeah.
remedy.
Contractual.
Talking about private remedies where the choices are with the contracting parties
Correct.
to decide how our remedy should work out. It's a different matter. I mean, in a contract where there is a conflict of interest, contractual principles will resolve that conflict of interest. But superimposing public law perspectives, as if these are public tenders, so where is the transparency? Where is the level playing field? Those principles, knowing very well, England has kept it aside completely when it came to private and judicial, private composition of judicial remedies.
Lord,
And we are not
As well as today, I mean,
Lord, why this is
in what
required?
we apply today, this reference is not only confined to PSUs. There'll be also
Private parties, yes, of
right?
course.
There'll be large corporations also.
Lord, Reliance versus GSW, hypothetical. There is no-
Any of our large companies.
Larsen and Tobro versus so and so.
Now, how would this whole concept of having one panel work in the private sector? What we
It cannot
because
work.
Brother
It cannot
Natsma
work.
says, to just bring a synthesis, what Brother Natsma's point is that
My
look,
lords are right.
we are
Absolutely.
essentially in the realm of private law. So
We are
in our effort to protect the revenues of the government, we must lay down a principle which applies across the board
Lord,
to
that-
all contracting parties.
Lord, let me answer that. Let me answer that
remedies
squarely.
are private.
Your lordships are.
There is a slight distinction between mediation and arbitration to the extent that it automatically becomes a decree enforceable. The meaning of decree being enforceable is that the state's power is behind a decree. Defined in a law.
Sovereign.
To that extent, it becomes public. But with respect to all other matters, choices of remedies,
Absolutely.
choices of
No, let-
and court keeps superimposing. Forget about that.
And my
Legislation
answer
is
is
another matter.
squarely, my lord, my answer is this. We are required to go into the question because the question in one line which has arisen is whether in a private field of a contractual relationship, there is a permissibility of a clause which permits panel to be prepared by one party. It is always open for others not to follow that.
No, if you are right that you can always prepare a panel, there's no difficulty. If you say that, well, others, it's only optional, they're not bound by it, then of course that resolves their argument. Now take the flip side, what you said, and apropos what fell from Brother Narsima. You are suggesting this essentially for the public sector context. Take a case of a private insurance company, all right, who has insurance dealings with individuals. They put an arbitration clause in a.
I have answers. My lord, can I show the
Now,
scheme?
every private insurer, will they say that, well, we will prepare a panel which will be broad-based, our process will be transparent, we will invite people to apply for our panel? There'll be like 100 insurance companies, 100 construction companies,
I'll be able,
100 engineering companies. How would that preparation?
I'll
of
be
the
able
panel,
to show examples, my lord, where banks have similar systems working very effectively, which is called online dispute resolution. I'll be able to, my lord, let us, my lord, start with this one. I think I started from a wrong side of
not-
the.
No, we are not,
We are
we are not,
discussing,
we
we
are
are
not
not
saying what
against
you're
you.
saying is, we are not against you.
No, I understand.
We
These are,
just
my lord.
trying to explore the limits of your submission, please. I mean, we
No, I
A
understand.
great deal
I'm
of, a great
conscious
deal
of.
of thought has gone on your part and your team into making these submissions. We respect that. We're not against you. We're just trying to explore the limits, because when we write a judgment,
Lord,
eventually we'll have to factor that
Your
in.
lordships would also examine and, my lord, bind parties where one company enters into a contract with another company. The question will be, if one company says that we will have a broad-based panel out of which you will have to elect, would that pass the muster? Yes.
Solicitor, invariably we are getting into areas of intersection of public law and private law.
Correct, my lord.
Where does public law come in? Even if it is a private contract between the parties, if there is a clause which is unconscionable, to that extent, in public law, we will set it aside. Therefore, that will come in the realm of public law proceedings. But if we go further and then say that clauses should be of this nature, clauses should be of level playing field, and start prescribing the method and manner by which private parties could compose their the private remedies, then it has, the distinction is completely done away with. Only
I bow down.
Only that far and no further. All these arguments are in fact arguments in the realm of public law, saying that you can't have a unilateral clause. So that should lead to, like in O'Reilly versus Macman, file a petition before a public law court and say this clause is invalid. You can't have a contract, section 28 of the Contract Act is actually invoked. So to that extent, the clauses could be set aside, because if there
In
is
an
a
individual
element in
case.
the contract, that we will do, that remedy we can give.
In an individual case,
To administer a private.
it cannot be done. My lord, can I show, my lord, how the
So
private?
one more thing I would like to add. Ultimately, what jurisdiction will we be exercising? We'll be exercising the 142 jurisdiction of this court.
No, but my
Now,
lord, ignore
otherwise
that.
We have no such power. As a court, we have no such power. Now, exercising the 142 jurisdiction to lay down structural parameters for composition of arbitral tribunals, I dare say that, we'll be soundly criticized in the world of, business and,
Something which I would, my lord.
what has the Supreme Court done? Because, so.
No, I'm not on that, my lord. I think we are completely on different,
Versus Macman.
You see, the panel that you are proposing,
Because
well, forget the panel for the time.
all right, I mean,
Let us park it.
but what has been suggested is, it will definitely address the concern about impartiality, independence, integrity. But then it does not address the concern of party autonomy, which is very relevant in the realm of
Yeah, exactly, my lord. There, I'm sorry. I'll show it from the act itself. Let me, my lord, now confine to the act. Now, my lord, as my lord Justice Narasimha has rightly said, that this is to be, the answer has to be found from the private law remedy of contract. My lord, please have a look at, my lord, the Arbitration Act. Let us see, my lord, what the act says. Now, forget, my lord, the government or public sector undertakings. Let us see, my lord. Lord, please come to Chapter 2. No, your lordships possibly are referring to the book, my lord, not the.
We can go to the soft copy.
No, I'm.
Where is the soft copy of
No,
the
no,
act?
I'm the better.
No,
This is better. This is better.
We're making sure that you also become completely digital.
No, my lord, I am using digital, my lord. I am using digital, but for the act, my lord, I prefer the bare act.
Bravo.
Now we are in a private domain. My lord, we are in a private domain, and kindly, my lord, keep two examples in mind, which are, my lord, for example, public sector undertaking. I am not obsessed with that while answering this question, but public sector undertaking having an apprehension that exclusive choice would result into a kind of not neutral or not impartial situation. Number two, kindly bear, my lord, these examples in mind. I'm not naming the company, but it is a part of a judgment of this honorable court, and I have filed an affidavit. I'm sorry, my lord, just
Yes, no.
is on something else.
Public sector
Yes.
company.
No, first is a public sector company, my lord, having no level playing field. They choose the arbitrators, particular arbitrators of their choice. And my lord, there is an apprehension that we usually end up, my lord, not having a level playing field. And I know your lordship knows what is the meaning of that expression. Second example, now in a private domain, there is one company of which I know, and it's a part of the judgment. It's a construction company of a big scale. They enter into contract only to ensure that the contract is eventually terminated midway, and they file arbitration and earn a big award. And I have filed an affidavit on behalf of the company that their main income is out of arbitral awards, not from the business. Now, I am a private company. I am a Larsen and Toubro. I am JSW. I am entering into a contract with that company. And I am saying that this is going to be my clause in the contract. You take it or leave it. It's a voluntary act. This is, my lord, second example. Please bear these two examples in mind and see how the scheme of the act operates. There is, in every section, every part, there is a party autonomy ingrained. It's not something, my lord, which a party which is insisting for a panel is doing for the first time or doing contrary to law. Lord, please have a look at section 4 now. Develop the
that if you have a
contracts also between A company and B company. There are apprehensions that B company may have a better level playing field than A company in private contracts. But forget everything. Let us see, my lord, what the Act says. And whether,
Let's read, we'll read the provision of the Act and see how you're reading.
yes, my lord. And whether if the Act does not prohibit, alternatively, if the Act permits one party to have a clause regarding there being a panel, which right now, my lord, there is doubt whether it is permissible or not,
So let us
whether the Act permits.
we'll read
Please
the
come
Act.
to page section 4. Section 4. Section 4. I'll invite your lordship's attention to only relevant clauses, my lord, just to which assess the court, my lord, in this particular question. Section 4, your lordships have, my lord. I'll read. A party who knows I'm sorry, can I read, my lord, if you lord? A party who knows that A, any provision of this part from which the parties may derogate, or any requirement under this under the arbitration agreement has not been complied with, and yet proceeds with the arbitration without stating his objection to such non-compliance without undue delay, or if a time limit is provided for stating that objection within that period, shall be deemed to have waived his right to so object. My lord, the meaning, as I have understood, is that party, if it is clear that some provision is derogable, but agrees to it, or there is some requirement in the arbitration agreement, but permits it to be waived, if I may use, my lord, my expression, then it is prevented, meaning thereby
There is estoppel principle.
correct, my lords. Meaning thereby
Estoppel because
estoppel, your lords are right.
principle of estoppel not against a statute will not apply here. No estoppel will apply.
The statute operates as an estoppel. The statute says your conduct operates as estoppel. We don't have to borrow the.
Now, what do you think are the derogable provisions?
Pardon, my lord?
Which are the derogable
My lord,
provisions?
I'll come to that, my lord. Kindly, my lord.
Just bear that in mind. Later on,
I know, my lord. I'll have to answer that, my lord. My learned friend has says 34. I have something to say on that, my lord.
all right,
And
then section 4, then what is?
Section 4. My lord, this says party autonomy. You can have a provision, and by conduct, you can waive that provision, and thereafter don't object because you are stopped from objecting. That is section 4. Now, please see, my lord, the title of chapter 3, and this is, my lord, relevant. The title of chapter 3, which is section 10 onwards, is composition of arbitral tribunal. Your lordships are
Going back to 4, 4 is in two parts. The first part deals with derogable provisions of the Act.
yes, my lord.
The second deals with the arbitration agreement.
Correct.
A requirement of the arbitration agreement.
Yes.
If you don't raise it at the earliest possible opportunity, you are stopped thereafter. You
I'll
can't
just
raise.
give an example what it means.
It's like the CPC says, objection as to place of suing or territorial jurisdiction. You don't raise a point of territorial jurisdiction at the earliest possible opportunity. You can't raise it later on.
Correct.
If it's otherwise a court of competent jurisdiction, you can't say that the suit was filed in Gurgaon instead of Delhi later.
Another example, my lord, what B means. My lord, your lordships have come across.
Like on that.
Your lordships have come across several arbitration clauses. Generally, that arbitration will have to precede the conciliation. That there has to be a conciliation, and if it fails, then arbitration.
That's that clause B, requirement of the arbitration.
Exactly. So that suppose somebody straightway come to the arbitration, participates, then he cannot say that we have missed
No
one.
conciliation.
That's my lord, so this is party autonomy. Nothing turns on the question in hand, my lord. Now,
Like the
please,
MSME Act says, you must have conciliation and then arbitration.
yes, no, even in several agreements,
Yeah.
there is a provision for conciliation first and then arbitration. Now, chapter 3, composition of the arbitral tribunal. This is the only chapter which provides how arbitral tribunal can be constituted. And as per the definition, sole arbitrator is also a tribunal, multi-member panel is also a tribunal.
Yes.
Now, my lord, 10 is not relevant, my lord, for either of us. Please come to 11. The way, my lord, I would respectfully read section 11. And if my learned friends are right, then we will make one provision at least nugatory. Provision in the chapter of composition of arbitral tribunal. And your lordships would also simultaneously find the party autonomy, a tailor-made, customized agreement is in contemplation of the parliament. Everywhere, my lord, in every section.
Procedure for arbitration.
Yes. Now, 11, my lord. A. 1. A person of any nationality may be an arbitrator unless otherwise agreed by the parties. Here comes party autonomy and the freedom to enter into a contract. This is relevant only to show that parties can agree. The contract is supreme. But second is most important question, important provision.
Procedure for appointing the arbiter.
Subject to subsection 6, the parties are free to agree on a procedure for appointing the arbitrator or arbitrators. Lord, there can be an agreement which says that procedure will be as conventionally followed. I will select my arbitrator, other side will select his arbitrator, and both will request for someone to preside over. That can be one procedure. Another procedure can be you voluntarily enter into a contract which provides for an arbitration agreement which says that the procedure of appointment will be a panel of arbitrators. And you select one from the panel. Correct, my lord? Nothing prevents up to subsection 2 from parties in their act of volition agreeing into an agreement about the procedure for appointment.
Yes.
Now, this interpretation of subsection 2 gets further strengthened by subsection 3. Failing any agreement referred to in subsection 2. So, procedure of your choice, party's choice. If you cannot arrive at or the arbitration agreement is silent, failing any agreement referred to in subsection 2, in an arbitration with 3 arbitrators, each party shall appoint 1 arbitrator, and the 2 appointed arbitrators shall appoint the 3rd arbitrator who shall act as the presiding arbitrator. So this is the second statutory option. First option is that you choose your method of constituting the
So
tribunal.
3 is an exception to 2.
To 2. So other than this conventional method of one electing one selecting one, another selecting second, and they selecting presiding arbitrator is an exception if there is no other customized mode of arbitration tribunal constitution is provided for.
If parties have provided for a procedure for appointment,
Yes, my lord.
then that will govern.
That will govern.
So that shows that that procedure for appointment is a derogable provision. Isn't it?
Yes.
Subject to, it's a derogable provision. The very fact that he says that it's failing an agreement,
Correct.
show that
It's the-
once there's an agreement, that agreement prevails.
Yes. Not even one is derogable. That arbitrator can be,
Even a sole arbitrator.
yes, arbitrator can be of any nationality, is also derogable. That unless parties otherwise decide.
The only non-derogable provision is it shall not be an even number.
Yes, it can't be. It can't be. Then, my lord, 3A. The Supreme Court and the High Court shall have the power to designate arbitral institutions from time to time, which have been graded by the Council under Section 43(1) I for the purpose of act. My lord, I'm skipping the proviso. Please come to 4. Subsection 4. My lord, this may not assist your lordships. My lord, 3A will have no relevance for this question. Your lordships are on subsection 4, my lord?
Yes, 4.
4. If the appointment procedure in subsection 3 applies, meaning thereby no agreement. Subsection 3 is in absence of customized agreement. Then what? And if there is no such provision, 3 applies, then a party fails to appoint an arbitrator within 30 days from the receipt of a request to do so from the other party, or the 2 appointed arbitrators fail to agree on the 3rd arbitrator within 30 days from the date of their appointment, the appointment shall be made on an application of the party by the arbitral institution designated by the Supreme Court in case of international commercial arbitration, or by the High Court in case of arbitrations other than international commercial arbitration, as the case may be. So if there is no customized, I'm using that expression, agreement, then 3. If 3 is also not present, then 4. Then kindly come to 5. Failing any agreement referred to in subsection 2. The lordship has that, my lord. So there is no provision for a customized manner of constitution. In an app,
Just 4 or 5 minutes.
yes, my lord, your lordship may come after 10 minutes.
5 minutes.
I have some
Just
list
5
that
minutes. Just to stretch it. That's all. Yes, Mr. Chairman.
Wait, please. Lord, I was on subsection 5.
Yes.
Lord, your lordships would mark one thing, that 4 comes into play when 2 is absent. I hope, my lord, I am
Very fair.
correct, my lord. 4 comes into play when 2 is absent. 2 is absent when there is no agreement between the parties providing for the procedure.
Yes.
Now, that is first 4 when there is no agreement, then 5, subsection 5. My lord, 5, yeah,
Yes.
I'm sorry, may I read 5?
Yes.
5, failing any agreement referred to in subsection 2. So no procedure prescribed. In an arbitration with a sole arbitrator, if the parties fail to agree on the arbitrator within 30 days from the receipt of a request by one party from the other party to so agree, the appointment shall be made on an application of the party in accordance with the provisions contained in subsection 4. The highlight, my lord, which I would respectfully make is that 4 and 5 would come into picture only when there is no procedure under subsection 2. Justice Narasimha, my lord, I am able to make 4 and 5 will come only when there is no 2.
Yes.
Now, 6. Where under an appointment procedure agreed upon by the parties, that is under subsection 2, a party fails to act as required under that procedure, or the parties or the 2 appointed arbitrators fail to reach an agreement expected of them under that procedure, or a person, including an institution, fails to perform any function entrusted to him or it under that procedure. My lord, the procedure may stipulate. Just giving a hypothetical example, that in case of a dispute resulting into an arbitration, the arbitral tribunal would be constituted, say, by Delhi Arbitration Center. That can be, my lord, a possible, which is considered, my lord, under 6C. The appointment shall be made on an application of the party by the arbitral institution designated by the Supreme Court in case of international commercial arbitration, or by the High Court in case of arbitrations other than international commercial arbitration, as the case may be, to take necessary measure unless the agreement on the appointment procedure provides other means for securing the appointment. I'm sorry, my lords.
Yes.
Even 6 is derogable. Please see, my lord, 6, last line. If either of these 3 contingencies arise, namely, parties do not appoint, party appointed arbitrators do not appoint a presiding arbitrator, or if an institution is named in the agreement, the institution does not do anything, then the party will approach the High Court or the Supreme Court, but that is subject to last unless the agreement on the appointment procedure provides other means for securing the appointment. So even approaching the Supreme Court or the High Court is also a derogable provision by agreeing to it under an agreement made under 2. My lord, now, my lord, omit 7, it is omitted in 2019. Kindly come to 8. Your lordship has 8.
Yes.
The arbitral institution referred to in subsection 4, 5, and 6. Lord, 6, provided there is no contrary agreement. But let us take that there is an agreement. And either 4 or 5 or 6, the institution which your lordships have designated is approached. Before appointing an arbitrator shall seek a declaration, disclosure in writing from the prospective arbitrator in terms of subsection 1 of section 12 and have due regard to. Well, kindly pause here for a minute. The argument of Mr. Banerjee was that this part is non-derogable. I agree to that. I have a customized agreement under subsection 2. There is a failure and 4, 5 or 6 kicks in. 6 will kick in only, my lord, in case of 2. Correct, my lord? Am I clear? Subsection 6 will kick only when there is an agreement under subsection 2. But then 12 is non-derogable. You cannot appoint a disqualified person who is disqualified under section 12. I'll come to that, my lord. So, my lord, again reading, the arbitral institution referred to in subsection 4, 5, and 6. If we have 2, we are not concerned with 4 and 5. Before appointing an arbitrator, shall seek a disclosure in writing from the prospective arbitrator in terms of subsection 1 of section 12 and have due regard to any qualifications required for the arbitrator by agreement of the parties and the contents of the disclosure and other considerations as are likely to secure the appointment of an independent and impartial arbitrator. But we are not concerned with A and B because their argument was that 8 is non-derogable, to which I have no difficulty. My right under subsection 2, my volition and their volition to enter into a contract with a customized arbitration procedure, customized procedure for appointment of arbitrator, will be not bound by section 12. I cannot disqualify anyone. I cannot make my manager an arbitral award. But giving an example, how 8 operates. There cannot be an agreement under subsection 2 which says that my managing director will be the arbitrator because that is prohibited under 12. 12 mandate will apply to my choice and their choice in entering into a contract under subsection 2. Now please come to 12, section 12. Rest will not assist your lordships either way. And my lord, whatever I am skipping, your lordships can take it, is not relevant for either of us. My lord, in such matters, we don't argue, my lord, to win a case or lose a case. My lord, we really assist the court. So, 7. Ek second. It turns out. Lord, there are some provisions which came in 19, my learned friend Lord points out.
In fact, I was comparing it with your soft copy and then the hard copy because these are the post-19 provisions.
So you relied.
The institutional part of it is not.
Lord, it does not make any difference to the interpretation. I think he agrees. Are you agreeing or not?
I'm saying that this
technically,
section is technically not the correct provision.
So the correct provision of 8 is in footnote 2.
Correct. It is the Chief Justice, the High Court or the Supreme Court.
yes,
Chief
but
Justice
kindly
or the
read.
person so or institution designated by him in appointing an arbitrator shall have due regard to any qualifications required of the arbitrator by the agreement of parties and any other considerations are likely to secure the appointment of an independent and impartial arbitrator.
My lord, the sum and substance of what my learned friend says, and I agree, is instead of institution, please read the Honorable Chief Justice. That's all, my lord. Nothing turns on the interpretation or the issue we are confronted with. The Supreme Court or the High Court will also be governed by the agreement under 2.
And B says the contents of the disclosure, and so the disclosure has to be made before you appoint the arbitrator.
Correct.
And other considerations, that's very important, and other considerations as are likely to secure the appointment of an independent and impartial arbitrator.
Correct, my lord.
This seems to suggest that even where parties have agreed to the procedure for the appointment of an arbitrator, but that procedure has not been implemented for a variety of reasons, you move to Supreme Court. Supreme Court is not bound, or the High Court is not bound by that procedure. That's the point.
No, my lord.
There are a line of 3 judgments of Justice Lora where under the agreement, there is an obligation to appoint an arbitrator, but one of the parties has not complied, so 11.6 come into the play. It was argued at that stage that now 11.6 has been filed, but when a court appoints, you must appoint according to the arbitration agreement. He has rejected that argument, saying, number 1, that freedom no more exists because of non-compliance of you. Now the power and right exclusively rests in the court itself. And we will appoint, and when the court appoints, the procedure contemplated under 8A and B will apply. Those are the line of cases. Sir.
In case of non-compliance, we are concerned.
Right, obviously.
Issue arises only on non-compliance.
We are concerned whether 2 can have a particular procedure or not.
Of course, 2 can have a procedure.
But my lord,
But if that procedure has failed and the matter comes to the court, then you are not bound by the rigors of the procedure which have been provided by the parties.
Well, certainly, but please read 8 again.
Because when the court appoints, there is an overarching duty of the court to protect independence and impartiality. And therefore, the court is not merely a rubber stamp to say, okay, I'll look at the agreement and I'll appoint the same person or the same people, however lack of independence or impartiality they may be.
No, that's not my argument also. I am not, my lord, pitching it that high, but please read it again. 8. My lord, what would be your lordship's consideration, the Supreme Court or the High Court's consideration? The Supreme Court, or as the case may be, High Court, or the person or institution designated by such court before appointing an arbitrator shall seek a disclosure in writing from the prospective arbitrator in terms of subsection 1 of section 12 and have due regard to. So this is disqualification disclosure and due regard to. A, any qualifications required for the arbitrator by the agreement of the parties. Suppose, my lord, agreement of the party says a chief engineer will be appointed. Then your lordships will have a regard to that.
That's because earlier set of cases said that even if court appoints, it must go by the agreement.
Yes.
That
is
got
1940
after
Act.
the amendment and the 2 judgments also.
Yes, 1940 Act. Those. Then, and second, the contents of the disclosure. My lord, disclosure means, I'll come to
by the prospective arbitrator.
12, the disqualification. The contents of the disclosure and other considerations, which is, my lord, a wider, completely wide room, my lord, for the court, my lord. So apart from disclosure, your lordships can likely to, will appoint a person who is likely to be independent and impartial. So, my lord, sum and substance is, there can be an agreement under 2, complete autonomy. If there is an agreement, but conditions not complied with, you come to 6. While exercising powers under 6, your lordships will examine 8.
But if there is no failure of the procedure, then parties are bound by what is envisaged in that procedure under 2.
And therefore, 2 Yes, but 2 does not prohibit parties to agree to a particular procedure which may include a procedure of selection from the panel.
Invariably, 11 is filed on the ground that I've asked for arbitration, but they are appointing from the panel. So 11-6 is filed on that ground.
No, but they cannot, if they have agreed under.
Cannot, it's your argument.
That's my submission. Yes, yes. The lordships are right. So long as 12 is met. So now kindly come to section 12. Section 12 again is housed in the chapter titled Constitution of the Tribunal, Composition of the Tribunal. Am I with your lordships on section 12?
Yes.
When a person is approached in connection with his possible appointment as an arbitrator, he shall disclose in writing any of the circumstances. My lord, he shall. This is non-derogable.
Yes.
So he must disclose, my lord, either approached by the party as per the procedure prescribed under section 11(2) or maybe by the Supreme Court or the High Court. A, such as the existence either direct or indirect of any past or present relationship with or interest in any of the parties or in relation to the subject matter in dispute, whether financial, business, professional, or other kind, which is likely to give rise to justifiable doubts as to his independence and impartiality. Kindly see, my lord, the clauses, because this does not disqualify him. The only my lord, responsibility is to disclose. Then B. And B, my lord, I have a separate submission to make, my lord, for your lordship's kind consideration, which are likely to affect his ability to devote sufficient time to the arbitration and in particular his ability to complete the entire arbitration within a period of 12 months. This is what a prospective arbitrator is supposed to give. My lord, I'll come to that point. I'm not raising it right now, my lord, but this is a very, very vital point, my lord, which will go to the root of the issue. Then explanation 1. The grounds stated in the 5th schedule Lord, in ICC arbitrations, when an arbitrator is appointed, I'll show, my lord, when I come to that. Sorry. In ICC arbitrations, prospectively is approached. Lord, in ICC, Lord, I'm not, Lord, I'm not arguing this right now. At the end, I'll say, but just as a by way of an information, in ICC arbitration, whenever a prospective arbitrator is approached, he is requested, there is a format that give me your calendar of 24 months henceforth. They decide whether he is able to devote sufficient time and whether the arbitrator would be able to complete it within a time period. I'll come to that, my lord, but that a little later. Now, my lord, 2. An arbitrator, subsection 2, from the time of his appointment and throughout the arbitral proceedings shall, without delay, disclose to the parties in writing any circumstances referred to in subsection 1, unless they have already been informed of by him. Suppose some disqualification, not disqualification, some contingency under 12(1)(a) occurs during the arbitration. So he is supposed to disclose that. So throughout the liability of disclosure continues. Now 3, an arbitrator may be challenged only if A, circumstances exist that give rise to justifiable doubts as to his independence or impartiality. Kindly pause it here pause here for a moment. Lord, this is one of the grounds on which his appointment can be challenged. And if your lordships can now read it with explanation 1, appended to, my lord, immediately after B, subsection B. The grounds stated in 5th schedule shall guide in determining whether circumstances exist which give rise to justifiable doubts as to the independence or impartiality. So this is to be connected with or read with 3A. 5A grounds are generally the guiding principles, but they are not, my lord, the exhaustive list. There can be other, my lord. One of my learned friends said that there is one arbitrator in the panel who always decides in favor of one party. Maybe that can be a ground, my lord, under 3A, that we have a reasonable ground that he is not neutral, he is not impartial, he is not independent. Then B, he does not possess the qualifications agreed to by the parties. Then 4, a party may challenge an arbitrator appointed by him or in whose appointment he has participated only for the reasons of which he becomes aware after the appointment has been made. If he is already aware when the appointment was made, then waive. It is derogable. Then he cannot challenge, a stopper. You cannot challenge. Then 5. 5 is, my lord, non-derogable. Please see, your lordships have seen 12(1), mere disclosure, no consequence. Now 5, notwithstanding any prior agreement to the contrary, any person whose relationship with the parties or counsel or the subject matter of the dispute falls under any of the categories specified in the 7th schedule shall be ineligible to be appointed as an arbitrator. This is the distinction between 1 and 5.
Yes.
So 1 is mere disclosure, 5 disqualification, he is ineligible. Lord, this will govern 11(2) also. There cannot be an arbitration clause which permits a person falling under 12(5) to become the arbitrator. That is non-derogable.
So Schedule 5 can be derogated from. Parties may say that, well, despite the fact that there may be justifiable doubts as to his impartiality and fairness, I still accept him. So,
I
but
can challenge-
7 schedule is ineligibility.
Yes, exactly.
Exactly.
I understand, but if I agree to 7, I necessarily agree to everything which is in 5
What
akin to 7.
Family arbitrator, suppose you.
There's a waiver, my lord. Family arbitrator, there's a waiver under 12(5) proviso. You can waive it
Waive afterward.
afterwards. You can waive
After
it.
dispute 7 period.
And that's what the law commission says in paragraph 60, that in family arbitrations, you can waive it. That was one of the examples.
Right.
Yes, because it's always advisable that someone related is the arbitrator. My lord, please see the proviso.
This waiver under 12.5 proviso,
Yes.
it is subsequent to dispute. having-
Subsequent, yes,
They can
yes,
do that
yes,
at
yes.
that stage.
It cannot be at 11-2
It
stage.
not be at the stage.
And it has to
beginning.
be,
An
an-
express agreement in
and
writing.
it has to be an express agreement. in writing.
Express agreement. Yes.
I know that the arbitrator is my uncle, but we both agree to his arbitration.
My lord, therefore, we are not concerned with such a scenario, but absent the proviso and the agreement contemplated, even in family arbitration, 7 would kick in. So, provided that parties may, subsequent to the dispute having arisen between them, waive the applicability of this subsection by an express agreement in writing. So, this is not, my lord, this is to be contrasted with other provisions where you can, by conduct, condone ineligibility or disqualification.
Is there any other provision which uses this expression, notwithstanding any prior agreement? Because this is the only provision, I think, which overrides an agreement.
This is, my lord, subject to correction, but other provisions are subject to the agreement to the contrary.
Yes, it's the converse. So
Ah,
therefore,
this is
shows
notwithstanding,
importance.
more rigorous. Otherwise, possibly, my lord, the effect is same.
There's some commentary which I showed yesterday, which said that that list was not drawn up because you could make out wherever it is subject to the contrary, it is not mandatory, and where it is not, it is.
No,
That was
that's my lord comment. I have something, my lord, I have some reservation. Commentaries, my lord, are ultimately views. But notwithstanding anything to the contrary, or at the end, subject to the contrary agreement, would have the same impact. But notwithstanding anything contrary to the agreement, means the statute provides, prevails. Correct, Manoj? But statute is exempted by the provision by saying that except where parties agree otherwise. So they are converse situations. Yes. Now, my lord, please see.
Section 5 provides for non-derogability in its substantive part, but that is relaxed by the proviso where there is an express agreement between the parties after the dispute has arisen.
Yes, I'm,
Why after the dispute has arisen? Because parties are conscious of what is the nature of the contentious matter.
and the nature of this one.
Understanding the contentious matter, they expressly agree in writing.
That my maternal uncle would
This
arbitrate.
person
Although he may be otherwise related, not qualified.
cannot be upfront before the dispute has arisen. You must be conscious of the dispute and then expressly agree it in writing.
And this is just, my lord,
It's the exception.
academically for interpretation. Some of the provisions say that by conduct, you are deemed to have waived your objection. This is the provision where for 7th schedule, there has to be an express agreement, not merely by conduct or by inaction. By not objecting, you cannot waive. There has to be an express provision.
So
Now-
and the overriding of a prior agreement by subsection 5 is subject to the further exception carved out in the proviso.
Correct. Now, my lord, kindly see 14(1)(b). I'm just, my lord, saying that everything is party autonomy. You can contract whatever you want to contract. Because instead of a conventional litigation method, you are devising your own method of adjudication. Therefore, the entire act is replete with party autonomy, that you decide whatever you want to decide. Just as an example, 14(1)(b), the mandate of an arbitrator shall terminate and he shall be substituted if he withdraws from his office or the parties agree to the termination of his mandate. Parties can even enter into an agreement which says that now henceforth we are in the middle of arbitration, but we terminate your mandate. Everything is party autonomy driven. Then, my lord, please see next chapter, jurisdiction of tribunals. We are not concerned. I'm just, my lord, highlighting the, my lord, heading of the chapter. 16 is competence of arbitral tribunal to rule on its jurisdiction. And 17 is, my lord, interim measures. My lord, we are not supposed to read it. Now, please come to chapter 5. Now, thus far, your lordships were examining sections under the heading composition of the tribunal with which we are concerned. To whom? By दोनों साइड होती है.
We will finish by 1 o'clock.
Lordships would agree on 2 points. We started little late.
No sooner is.
I started, my lord, further late, my lord, I was answering. And this happens, my lord, when you are on the, to come to bed, my lord, after the first inning. And, my lord, I have not been repetitive or irrelevant, my lord.
Roughly how long?
Not more than, my lord, half an hour.
Try and sort of compress it as much as you can within half an hour.
I'll try.
We are trying to lay down.
Yes, my lord, please come to, my lord, chapter, I'm sorry.
You have been highlighting the principle of party autonomy which runs through the entirety of the act. That's what you're saying.
Yes, and, Lord, I'm also dealing with their submissions, my lord, which are made in my respectful submission out of context. That's what, my lord, I'm trying to show by saying that one chapter, composition of tribunal, is over. Now, my lord, chapter 5, conduct of arbitral proceedings. So the tribunal is constituted, whether it's a sole arbitrator or a multi-member tribunal. Now, how the conduct will take place, please come to 18, my lords. Section 18. Equal treatment of parties, your lordships have, my lord. My lords have, my lord.
Yes.
Equal treatment of parties. The parties shall be treated with equality. By whom? By the arbitrator. Because it is in the chapter of conduct of arbitral proceedings. And it next line, my lord, strengthens the interpretation, my lord, I am respectfully giving. The parties shall be treated with equality and each party shall be given full opportunity to present his case. By whom? By the arbitrator. This does not talk of equality in terms of the contract under 11.2. This is before the arbitrator. The tribunal is constituted and now proceedings are going on.
Here, the argument of the other side was that the conduct of the arbitral proceeding would also include the appointment and composition of the arbitral proceeding, the arbitral panel.
Yes, sir. I'm
And that is the,
mindful of that.
I'm sure that you are trying to address that,
Yes.
which was argued yesterday.
Yes, Manoj. Because composition is a separate chapter providing for every step of composition. Conduct has a separate chapter providing for every step in conduct. And unless, my lord, we give that meaning, my lord, how would we reconcile 18? The party shall be treated with equality by whom? By the arbitrator, and it gets strengthened, and each party shall be given a full opportunity to present his case by whom? Obviously, during the conduct of arbitral proceedings by the arbitrator. So this equality is not equality of entering into an agreement under 11.2.
This is the manner we also read it,
Yes.
as we read yesterday, because it is immediately followed by 19, which talks about the procedure. And that will be governed by the arbitral. But the argument is that no, even at the stage of appointment, this equality principle should come.
Not treated equally by whom? We are two parties. We can't treat each other equally. We can contract that one will not be equal to the other. It's an act of volition. It's purely in a private domain, private law. When it says giving an opportunity of hearing, my lord, would we give opportunity of hearing to each other? When it is, my lord, under the heading conduct of arbitral proceeding with a mandate that everyone will be heard, means by the tribunal. There cannot be, my lord, with profound respect, any other meaning given to it. To come out of this argument, my lord, the reliance is placed on 21. Now, please come to 21. Unless otherwise agreed by the parties, the arbitral proceedings in respect of a particular dispute commences on the date on which a request for that dispute to be referred to arbitration is received by the respondent. The argument is that it is only after this notice, arbitration notice, that the tribunal is constituted. And therefore,
Yes.
18 should be read as
Commencement.
commencement. Lord, why this section 21 is placed in this chapter? Not to ensure that the entire chapter applies to the initial appointment of initial contract, which would determine the method of appointment of arbitrator. Please come to my lord 23. Within a period of time agreed upon by the parties or determined by the arbitral tribunal, the claimant shall state the facts when the claim will be made. My lord, there has to be a beginning of time, my lord, when the proceedings continue, proceedings start, that from the date of the notice, within 5 months, you must file your statement of claims because the object of the act is expeditious disposal. 21 is in this chapter only to ensure that parties can use that date as a starting date for filing statement of claim, filing defense, filing documents, etc., etc.
Earlier, on the 40 Act, commencement was declared to be from the time when an arbitrator enters reference.
Correct, my lords.
That they have deliberately changed it to.
Yes, my lord. But my lord, even 21, my lord, please come to 21 again. I'm obliged, my lords. Please come to 21 again, my lord, on my request. Unless otherwise agreed by the parties.
It's a derogable provision.
Yes, so we can say that the date of commencement would be the first meeting of the arbitral tribunal. This is why it is housed in the chapter which provides for conduct of arbitral proceedings. My lord, one more I missed, my lord, I'm obliged to my learned friend.
Procedure will be subject to.
My lord, I'm obliged to my learned friends, my lord, I missed section 19, which furthers my, my lord, respectful interpretation of 18. Please see, my lord, 19. The arbitral tribunal shall not be bound by the Code of Civil Procedure or the Indian Evidence Act. Subject to this part, the parties are free to agree on the procedure to be followed by the arbitral tribunal in conducting the proceedings. Failing any agreement referred to in subsection 2, the arbitral tribunal may, subject to this part, conduct the proceedings in the manner it considers appropriate. So 18 is during the conduct of arbitral proceedings. And 19 presupposes that there already a arbitral tribunal in existence. It is constituted under chapter 2. Now, my lord, please see the first line.
Really would stretch to its logical conclusion mean that the requirement of equality under section 18 would override even an agreed procedure.
Agreed procedure, and my lord, it would make the second part of 18 redundant, that parties will be given full opportunity of hearing. By whom?
Yeah, because
It can't be by each other that I will hear him and he will hear me.
the relationship is governed by agreement,
11
but the conduct of arbitrator must be equal.
equal.
If it doesn't, then 34 comes in saying that you would not. And it is,
Suppose, my lord, there is an arbitral agreement that they would not have a right of defense except on ABCD grounds. Then 18 kicks in. Then the tribunal is bound to treat both equally and give them full opportunity. Suppose there is an agreement that they will not be heard. Lord, 21 is housed in this chapter 5 because there is a provision for fast track arbitration agreement also. Parties can agree that now this would be the date. Date would be, hypothetically, the first meeting of the arbitral tribunal, and we agree that it would be over within 3 months. We put it on a fast track. Or this would be the date on which the arbitration has started, and we agree that within 1 month, pleadings will be completed. Therefore, to smoothen the conduct of arbitration proceedings, 21 is kept here. Lord, just quickly, 25, just first line. Just to show, my lord, party economy, autonomy is, my lord, writ large. It runs through the architecture of this act. Default of a party, unless otherwise agreed by the parties, this can be done. Then 26, unless otherwise agreed by the parties, the tribunal may appoint so and so. So parties are free to choose what they are contracting, what is their commercial bargain. Now, Lord, sometimes your lordships do something to achieve the ends of justice in a 226 jurisdiction, which arbitral tribunal also can be conferred with. Please come to section 28, subsection 2. This also is dependent upon the parties agreeing to confer their jurisdiction. The title is Rules Applicable to Substance of Dispute, but relevant, my lord, is 2, subsection 2. The arbitral tribunal shall decide ex equo et bono or amiable compositure only if the parties have expressly authorized it to do so. Otherwise, arbitral tribunal is bound by the terms of the contract. Now, your lordships, my lord, kindly come to 34. May I continue, my lord?
We'll come back after. So we'll ask. Try. Bench, we will, after the solicitor concludes, in the list which is given to us, we'll first hear counsel appearing for the parties. Then whatever time we are left, we'll give a little time to, the interveners. So we have Mr. Natraj for core, Mr. Arvind Kamath for BMRCL. Then we have Guru in Sundaram Finance, Ms. Madhuri Diwan for Mahindra Mahindra. Then we have Anand Padmanabhan for the petitioner in Equitas. And we have Suman Doval for the respondent in Nilcon. We'll give a little time to each one. And then whatever time remains, we'll ration out between the interveners and wrap it up today in the afternoon. All right, 10 minutes, one counsel on your side. All right. Now 10.
This is not derogable. Time is non-derogable.
I'm appearing for Tata Motor Finance. My application is filed. So, I request your lordships to let's direct my MA to be brought one.
Don't worry.
Lordship.
Yes, Mr.
On section 21, I'll show only two sections, and last section is 36.
So 21 we saw.
Pardon me?
21 we saw, right?
The lordships have seen. Lord, I have already pointed out 21, why it is there, that you have to have some date to count limitation from. In this context, please see section 43. Subsection 4.
Yes.
May I read? Lord, can we have 43 subsection 4?
Yes.
Well, the title is Limitations. And 4, where the court orders that an arbitral award be set aside, the period between commencement of arbitration and the date of the order of the court shall be excluded in computing the time prescribed by Limitation Act. That is why 21, that there has to be some date from which you count the commencement.
So then what is the commencement then?
And 21 also says, unless otherwise agreed by the parties. So the commencement date is also a fluctuating date, can be decided by the parties. And 2 also, subsection 2 of 43. For the purposes of this section and the Limitation Act, an arbitration shall be deemed to have commenced on the date referred to in 21.
Yes.
Similar is the provision of section 9, subsection 2. 9 subsection 2, your lordship has minutes. It has nothing to do with constitution of the tribunal, where before commencement of the arbitral proceedings, a court passes an order for any interim measure of protection under subsection 1, the arbitral proceedings shall be commenced within a period of 90 days from the date of such order. For this purpose, my lord, to compute the time from that date, it is, my lord, mentioned. Now, my lord, only section on which my learned friend Mr. Banerjee relied upon, section 34, my lord, please come to 34. S- 34, subsection 2, Roman 5, my lord, that was relied upon by him.
2A5.
2A5, sorry, I'm sorry, I stand corrected. 2A, subsection 5. The argument was, please read, my lord, first. The composition of the arbitral tribunal or the arbitral procedure was not in accordance with the agreement of parties. First, obviously, my lord, if it is not in accordance with the agreement of the parties, the award goes. 34 has this ground, my lord. Second, unless such agreement was in conflict with a provision of this part would mean part 1 applicable to domestic arbitrations. Part 2 is international commercial arbitrations. With a provision of this part from which parties cannot derogate. Lord, I have already pointed out that section 12 is the provision from which you cannot derogate. You cannot exempt disclosure, 5th schedule, and ineligibility in the 7th schedule. And therefore, if arbitral agreement provides for any of these non-derogable part, then 34 will apply, my lord, and the award would be set aside. So this would never, my lord, help my learned friend in canvassing that there is any restriction to section 11.2. And I have been able to show to in my respectful submission that everywhere the thread is party autonomy. Now, quickly, my lord, I'll take your lordships to my written submissions, my lord. But it is volume 5A. My lord, some of the judgments which I have reproduced, I'll not read. But I respectfully request your lordships that it may be treated as read, but in some cases, I'll give the gist of what it says. Lord, your lordships may come to the bottom of page 35, Centro Trade. Your lordships have this?
Which part is this? Part?
Part 1, part 2, my lord. Part 1, page 35. Argument submissions supporting one party having a neutral panel of arbitrators. Lord, ignore the title. Basically, there is no restriction, my lord, in having an agreement agreed to by the parties that the selection would be from one of the panel names. At the foot, my lord, clause 7, 5A, my lord, I'm sorry. Volume 5A.
Part 1 arguments.
Yes, my lord. Page 35.
5A, page 36.
My lord, Justice,
Got it.
Justice Mishra, my lord,
Yes,
my lord, sir. My lord, I am on clause 7. Your lordships need not read it. I'll just orally point out what the court held, my lord, in Centro Trade. It is essentially on party autonomy. My lord, this was a typical clause in a contract where, after an arbitral award, that award would be tested by another arbitral tribunal. The court said that it is odd, it is awkward, but nonetheless, we respect the party autonomy, and therefore, Lord, this was. Lord, kindly come to page 36. Lord, this judgment, my lord, in para 8. Lord, only highlighted part may be read, my lord, just for to save time. Therefore, you have this paramount public policy to consider that you are not likely to interfere with this freedom of contract. My lord, this is said in the context of arbitration. So this I am relying upon to show that there can be an agreed clause providing for a panel. Now, Lord, page 37 bottom. Lord, Russell on arbitration. Lord, this para I would like to read, my lord. Further, your lordship gets, my lord, page 37 bottom, clause 14. Russell on arbitration states, further, where the agreement is a commercial agreement, it provides that an arbitral tribunal is to be constituted from a panel wholly appointed by one side. The party not involved in the appointment cannot seek to attack the award on the basis that the procedure would result in an impartial tribunal. The rationale for this is that it is common in commercial contracts that one party has little choice when it comes to the arbitration provisions, and where that party has agreed to the arbitration procedure, they must be taken to have waived any objection. However, the position may be different where non-appointing party is a consumer. My lord, now your lordships may come to 16. My lord, this judgment, this is, my lord, Wilson Taylor Asia Pacific Private Limited. My lord, this is the judgment of Singapore Supreme Court, my lord, authored by Justice Sundaresh Menon. My lord, para 16, page 38.
Yes.
Yes, Lord, 16, Lord, part 4 of present written submissions, my lord. Lord, I'll take your lordships through page 65, my lord. No, not
So taking us to the judgment itself?
the judgment, my lord. Yes, my lord. I'm taking a lordship to the judgment itself. I'm sorry, my lord. I'm little slow in Ashok. Lord, it is
Volume 3, page
volume 3, page 4591.
93.
Come again?
Volume 3,
Yes.
page 4591. I'll read only one judgment. I'm not reading other judgments. I'll just para 8. Lord, this is Supreme Court of Singapore. Lord, which your lordships would find at page 4589. And His Lordship, the Chief Justice, delivers the judgment at 4591. I'll read only 3 paragraphs. Para 8, my lords, have my lords? Para 8, my Lord Justice Narasimha, Justice Adiwala.
Yes, got it.
The judge held, the impugn order is being discussed, the judge held that the clause constituted an arbitration agreement despite its asymmetrical nature. After an extensive survey of modern Commonwealth authority, the judge decided that a contractual dispute resolution agreement conferring an asymmetrical right, in other words, a right enjoyed by only one party to the agreement but not by the other, to elect whether to arbitrate a future dispute was nevertheless an arbitration agreement. Thus, he dismissed the respondent's argument of that the clause was not an arbitration agreement because of its lack of mutuality. The judge also held that the fact that a contractual dispute resolution agreement granted a right to elect whether to arbitrate a future dispute was nevertheless an arbitration agreement. Therefore, the characteristics of optionality in a dispute resolution agreement was not inconsistent with the meaning of the nature of an arbitration agreement. Summing up these principles, he concluded that a contractual dispute resolution agreement which confers an asymmetric right to elect whether to arbitrate a future dispute is properly regarded as so and so. Now, please come to page 4593, para 13. Now, my lord, His Lordship's finding starts. Page, para 13.
There are two things. Only one party could seek arbitration. They upheld that. And second, in respect of a future dispute, arbitration was made optional. They said still it's an arbitration agreement.
Yes, well, slightly, my lord,
Slightly different.
no, different, but slightly, my lord, more stringent case than what we have.
It can be a symmetry.
Even arbitrability was also one-sided. Lord, para 13.
Arbitrability was one.
Not only the selection of whether to arbitrate was also subject to one party agreeing. Ultimately, I will point out, my lord, wherever any country wanted to prohibit, they have prohibited by legislation, by choice. That will not permit one-sided appointment. Otherwise, my lord, party autonomy is, we can agree that, all right, only one party will decide. Here, my lord, that's not the
There are
case.
instances where statutory.
Yes, I'm coming to that. Yes, my lord, I'll assist your lordship with that. Lord, 13. In respect of the first of 3 requirements outlined at 11 above, we agreed with the judge and also the appellant that the clause constituted a valid arbitration agreement between the appellant and the respondent. It was immaterial for this purpose that clause A entitled only the respondent but not the appellant to compel its counterparty to arbitrate a dispute, the lack of mutuality characteristics, and made an arbitration of a future dispute entirely optional instead of placing parties under an immediate obligation to arbitrate their disputes, the optionality characteristics. On the weight of modern Commonwealth authority, which the judge considered, neither of these features prevented the court from finding that there was a valid arbitration clause between the parties and before us, neither party contends otherwise. Now, my lord, coming back to my written submissions. My lord, as a matter of fact, apropos my lord Justice Narasimha's query, my lord, just, my lord, हमने कोर्ट जो किया है. Lord, in yesterday, my lord, it was shown in uncitral model law, this restriction was suggested. My lord, I'll just, my lord,
You're right, but it was not specifically imposed because they said that two reasons they gave, three reasons. That the existing provisions are adequate and that it would lead to ambiguity in the law.
correct, my lords. Your lordships are right, my lords. Now, Lord, kindly come to page 41. My lord, I can skip. They have already argued, my lord, my case, so I'm not. I have put both the sides, my lord, of the coin, but they have, my lord, started and put their part of the arguments. Some of the judgment, my lord, which I relied upon, are also, my lord, relied upon by them. Of course, my lord, I must be thankful to Mr. Banerjee that he said that he is reading from my judgment. That apart. Lord, now, Lord, I am on a page 57 for a very important issue. My learned friend, Mr. Call, read one blog of Jan Paulsen. To satisfy your lordships, that unilateral arbitration clause is always to be frowned upon. My lord, your lordships recollects.
Yes.
Now, before I read this, my lord, let me clarify one thing, and this is where, my lord, I think inadvertently Mr. Call must have missed this. And I'll show, my lord, from his article itself.
Yes.
My lord, in international arbitration law, the word unilateral arbitration has different connotation. Wherever Jan Paulsen, Lord, he writes, his concept, my lord, and this is, my lord, very crucial for deciding or for, my lord, understanding the blog which Mr. Call, my lord, heavily relied upon.
Yes.
Lord, Jan Paulsen's understanding of unilateral arbitration is, I choose my arbitrator, other party chooses their arbitrator, and both of them choose the presiding arbitrator is unilateral arbitrator because we are choosing our own judges. And therefore, he is the proponent of the theory that arbitral tribunal has to be chosen by a neutral body. So he is not advocating institutional arbitration. He has been a proponent of institutional arbitration, that this system is wrong. That I select my choice of arbitrator, they select their choice of arbitrator, and both of them select one to preside over. That itself he treats as unilateral arbitrator. And my lord, just my lord, to show my lord from his blog. But first, my lord, please read my lord page 57. Lord, this is my paraphrasing, but I'll read it from the article also. Lord, please come to, let me read from the article so that my paraphrasing may be objected to because it may have my color. Volume 4, page 3662. In my volume, my lords. My lord, this is the article they have cited. My learned friend missed the first 3 paragraphs.
In the same compilation?
In the same compilation, your lordships may find volume 4.
Volume 4.
Page 3662. There is a habit. Tab 26. My lord. So this is what Mr. Call relied upon.
Yes.
Let
that's
us
right.
read, my lord, first 3 paragraphs. First 2 also, my lord, would be enough. What is his understanding of unilateral appointment? Then he frowns upon it. What could, your lordship gets, my lord Justice Particular.
Yes.
What could be more basic? Arbitrations begin with each side naming an arbitrator. References are occasionally made to fundamental right to name one's arbitrator. But there is no such right. Moreover, if it is existed, it would certainly not be fundamental. The original concept that legitimates arbitration is that an arbitrator in whom both parties have confidence. It is quite unlikely that a party will have confidence in an unknown arbitrator selected by its unloved opponent. My selecting would not be trusted by him, his selecting would not be trusted by me, and therefore it should go to a neutral body for the purpose of constituting the tribunal. He is advocating that. Whether he is pitching it too high, maybe he is right, we do not know, my lord. I can't sit in judgment. But this is his understanding. Now, my lord, please come to page 3663 at the bottom.
No, just read the last paragraph of 3662 also,
Yes, my lord.
the common practice.
The common practice of unilateral appointments of co-arbitrators may be said to be popular in the sense of being perceived as a valuable opportunity on which parties insist. This seems clear from the frequency of explicit contractual stipulations to this effect, as well as from similar provisions found in rules devised by arbitral institutions. It may seem surprising to ask whether this is compatible with the very concept of arbitration. Yet, it is a serious question. It touches on a simple but a profound matter. The legitimacy of arbitration rests on the party's confidence in arbitrators. There is every reason to doubt that any party is willing to have its case decided by its opponent's chosen arbitrator.
Just read next para also.
Yes, ma'am. The two main purported justifications for the practice of unilateral appointments are hardly convincing. It is said that 1, even Homer nods and therefore 3 heads are better than 1, especially when the stakes are high. And 2, parties will have greater confidence in the selection of arbitrators selected for their special knowledge or skill. So he is talking about my choosing mine and he choosing his.
The next sentence.
Yet, each of these objectives may just as easily be met when all 3 arbitrators are chosen jointly or by an appointing authority.
This makes clear that what he's really driving at is that the arbitrator should be selected by a neutral arbitral instance.
Third party, not so.
And unilateral appointment is referred to in the context of unilateral appointment of co-arbitrators. One is
Yes,
by each of the
one by me, one, and that
not where one party is appointed.
yes, then entire the meaning, context, and content of the entire blog would change if we understand Jan Paulson's understanding of what he means by the word unilateral appointment. Last para on this page. The only solution which will be reliable in all circumstances is that an arbitrator, no matter the size of the tribunal, should be chosen jointly or selected by a neutral body. This aspect of the process should no longer be misused as a sales argument for arbitration. Confidence enhancement is properly focused on procedural rights, the right to be heard, the opportunity, etc., etc. So, my lord.
So where there are unilateral, that arrow also, very specifically deals with unilateral appointment.
Yes, as understood by him.
Not so when there are unilateral appointments. It's obvious that a very different impulse is there. Introducing and understanding element into the of the arbitral tribunal. Disputants tend to be interested in one thing only, a favorable outcome. They exercise their right of unilateral appointment like everything else with that overriding objective in view. The result is speculation about ways and means to shape a favorable tribunal, or at least to avoid a tribunal favorable to the other side, which is logically assumed to be speculating with the same fervor and towards the same end. Forgotten is the search for the arbitrator trusted by both sides. So he talks about unilateral appointments.
Lord, I can do one thing. Lord, Jan Paulson has written a book idea of arbitration. I'll supply that book. This is his understanding of unilateral arbitration. The way we conventionally, my lord, understand, I select my arbitrator, they select their arbitrator, and third person is presiding. That is his understanding.
But in any case, he is canvassing, as we understand, appointment of arbitrator by neutral institutions. That is what he is ultimately
So
canvassing.
we are dealing with ad hoc arbitrations. We are not.
It's a view, it's just, it's a view of.
And
very
it is
well
a
done
good
in
view, my lord. It's a new, institutional arbitration is always preferable. But that's not the issue before the court right now. We are dealing with ad hoc arbitrations. So therefore, my lord, his view, even if right, will not support the view that a panel is unilateral according to Jan Paulson. Now, my lord, page 58, Gary Bond, my lord, I'll only read one line, my lord, because it is on the same principles, but for page 59. My lord, of course, these are all views. Ultimately, your lordships, in my respectful submission, will have to construe the act. Whether it
Many of us,
permits or
according to
prohibits.
Party autonomy is one golden thread which runs through the provisions of the Act.
Entire.
If the legislature intends to override party autonomy, that overriding of party autonomy must be expressly set out and then indicated in such terms by the Act, which our Act has not done.
As under 12.5.
Lord, only one para, page 59, third unnumbered para, highlighted part. Lord, para, unnumbered para 3, Lord, this is Gary Bond. I'm told it's considered to be an authority.
Yeah, page
59, Lord, I rely on my friend, Lord, who has, Lord, the domain expertise. But page 59, although the issue is often, Lord, I have highlighted it. It's in bold. Although the issue is often highly fact-bound, most courts have upheld provisions in which one party provides a list of potential arbitrators from which the other party must choose an arbitrator. World over, this is global jurisprudence. The only condition is they should be neutral. They should not be my employees or related to me. In other words, they should not have the ineligibility contemplated under Section 12.
All right. What's next, Mr.
Yes.
Secretary?
My lord, limited scrutiny post arbitration, my lord, also, my lord, is one of the factors, because when I choose my arbitrator and they choose their arbitrator, and when there is no level playing field, my lord, in persuading the arbitrators, my lord, when we lose, when we suffer an award, so there is, my lord, your lordship knows, my lord, what happens in 34, and rightly, for good reason. They have a right to decide wrongly also. We can't go into it unless some strict ground mentioned under 34 is made out. So this would disincentivize the arbitration as a mode of dispute resolution. Therefore, my lord, limited scrutiny of 34 may also lead, my lord, to an inference that kind of a neutral body that is not connected with me, what, my lord, American court says, intrinsically connected to one party, like my managing director, my consultant. But now I'm not reading. Lord, there is one judgment, and I would strongly, but I'm not reading it right now because of lack of time. Lord,
What
there
is saying, the limited ground, so far as the.
Lord, limited ground.
So therefore, that's the ground for challenge.
Lord, just to ensure that please approve a contract which I am permitted under 11.2 that from my neutral panel, they will select. They will not select as per their choice. So that 34 virtually is an illusory remedy. You know, that's the submission. Well, there is one. Lord, I'll not read one judgment, but I would strongly recommend that all my lords may read this judgment, my lord, because of lack of time, I'm not reading it. It makes a very interesting read. The Honorable Court, my lord, it's an American judgment, has, my lord, its Board of Education of Berkeley versus W. Harley Miller. Lord, it is a part of our written submissions, my lord, dealing with asymmetrical clauses like this. That one party having a dominant right.
Where did you mention about that?
Yes,
Just
Uh,
the page, that's all.
page 1670.
The written submission.
I'm sorry, 1668. I'm sorry, 1663. It starts.
In the precedence compilation.
Yes, no, our compilation. Our compilation, volume 5. Lord, why?
Yeah. 165.
It starts 1663 at 1670.
It's PDF 1665.
I'm great.
1670, okay.
I'll read two paragraphs and rest your lordships may read it. It makes an interesting read. It ultimately concludes, my lord, what I am respectfully urging for your lordship's consideration. But the way in which the judgment is written, my lord, makes an interesting reading. The basic problem, my lord, somewhere, lord, right-hand side column, second paragraph from the bottom, my lord, your lordship gets the basic problem.
1670.
1670, my lords.
Right side.
Right-hand side column, second para from bottom. The basic problem, your lordship, my lord Justice Padiwala. It's very interesting, my lord. I have read it fully, but your lordships may read it at leisure. The basic problem in all arbitration cases could probably best be explained not in terms of legal characterization such as condition precedent, ousting courts of their jurisdiction, or revocability, but rather by a hypothetical case in the tradition of ancient fabulist Aesop. Let us assume for a minute that for some reason all rabbits and all the foxes decide to enter into a contract for mutual security, one provision of which were that the dispute arising out of the contract would be arbitrated by a panel of foxes. Somehow, that shocks our conscience and it doesn't help the rabbits very much either. Now, what happens if we have the same contract with the same arbitration provision, except that disputes will be arbitrated by a panel of wolves? Is there such a community of interest among foxes and wolves that the wolves cannot be impartial? Possibly. Now, what happens if the dispute will be resolved by a panel composed by one squirrel, one elephant, and one wolf? One might conclude that squirrels look like rabbits, wolf look like foxes, and elephant ought to surely be, etc., etc. But eventually, it says that elephant will surely be impartial. Then animal law becomes procedurally very complex. Well, I'm not reading it, but it ultimately reaches a conclusion that this unilateral in the way in which we use it is not illegal. Can go to Lord, please come to, my lord, last 2 points and my lord, I know your lordships are looking at the
No, no,
watch, my
we
lord.
were just on something, just,
Okay. Otherwise, I can ensure your lordship.
over a long day of work, we have to have some pleasantries also.
I understand, my lord. But so long as your lordships are looking at the watch, there is no difficulty. I promise my lords will not be required to look at the calendar.
But here, the example, the rabbits will jump and the fox will trot.
An elephant is treated to be a neutral, obviously, because he doesn't look like either of them. Squirrels resemble rabbits and foxes resemble wolves.
Canine justice.
Yes, your lordships are right. Well, that's the word. Well, 65. Kindly come to page 65. My Lord Justice Narasimha, my Lord,
Of
this
the
question.
written submissions, no?
Yes, my Lord. My written submission 65, part 5. Asymmetrical arbitration agreements in different jurisdictions. But first, two, my lord, in global context and present context, my lord, would be relevant because globally it has different shades, my lord. Asymmetrical has different meanings, not the way, my lord, we understand it. My lord, first, global context. Lord, kindly come to the table directly, my lords. Lord, please come to page 65. Lord, there is a table given. My lords have.
Yes.
Lord, the purpose is to show that whichever country wanted to expressly prohibit one party to provide for a panel, it is so prohibited statutorily. And there is an exception made to the autonomy, party autonomy. Lord, Netherlands, for example, your lordships may kindly, Lord, remember the color scheme, Lord, the legend. Green is permissible and the other color is impermissible. Lord, kindly see the underlined portion. This is, my lord, the statute in Netherlands, Dutch Code of Civil Procedure. Your lordship gets, my lord, that page.
Yes.
If the, my lord, I'll read, my lord. My lords are taking.
Yes.
Page 65, my lord, Netherlands, the statutory prohibition. We don't have, my lord, I'm not repeating. If the arbitration agreement, I'm reading the underlined part, this is the statutory language. If the arbitration agreement gives one of the parties a privileged position with regard to the appointment of the arbitrator or arbitrators, the other party may, despite the method of appointment laid down in that agreement, request the provisional relief judge of the district court within 1 month after commencement of the arbitration to appoint the arbitrator or arbitrators. So the law does not permit, or rather leaves it open for the other side to not agree, even if agreement is providing. Then next is Germany. Similar, my lord, I will not read it. Same, my lord, it is same. Page 66. Third is Spain. Spain, my lord, page 66.
Yes.
Article 15.2 of Spanish Arbitration Act. Please see 2. subsection 2. The parties are able to freely agree on the procedure for the appointment of the arbitrators, provided that there is no violation of principle of equal treatment. In the absence of any agreement, the following rules shall apply. But my learned friend wants to read 18, which is an equal treatment by the arbitrator in 11.2. This is how 11.2 could have been if the legislature so intended. I hope, Lord, I am able to make myself clear. 11.2 would have been in this manner if they wanted 18 and 11 to be read together. Then your Lordships may, my Lord, come to page 67, again Spanish, my Lord, subsection 6. Not necessary. My Lord, kindly come to 68. Estonia, my Lord, section 721.2 of Estonia Code of Civil Procedure, my Lord, para 2, subsection 2. If an arbitral agreement gives one of the parties in the formation of an arbitral tribunal an economic or other advantage over the other party, which is materially damaging to the other party, such party may request that the court appoint one arbitrator or several arbitrators differently from the appointment which already took place or from the rules of appointment agreed upon earlier. Clear statutory mandate that you cannot have this. It is derogable. You can agree, other side can agree, or they go to the court. Poland, same. Russia, same. I'm sorry, Manoj, Your Lordship. May I assist Your Lordship with any section, Manoj?
The argument was that a similar provision is made in 11.8. 11.8 implicitly recognizes that. That is
11.8, Manoj.
11.8. Other considerations as are likely to secure the appointment of an independent and impartial arbitrator.
Yes, Lord, but 11.8 kicks in. So please, Lord, allow me to repeat a little while. Please see 8. The arbitral institution referred to in subsection 4, 5, and 6.
No, the unamended provision is in footnote 2 at the bottom.
Yes, Manoj.
The Chief Justice of India, the person or institution designated by him in appointing an arbitrator shall have due regard to A, the qualification, and B, other considerations as are likely to secure the appointment of an independent and impartial arbitrator.
Yes, Manoj.
So therefore, their argument was that when the court exercises the power, you are not hidebound by.
The court is not bound, but that's not, my Lord, my argument.
Court is not bound.
But 11. Lord, when a party goes to the court, Lord, when the party would go to the court under 8, in case of the contingency stipulated under 6, please see 6.
Then the court has a wider power.
No, Lord, I'm saying something slightly different. 6, kindly see 6. 8 comes only when we reach the court. We reach the court only if 6 contingency arise. Please see 6, Lord. Where, Lord, the same page, Your Lordship, where under an appointment procedure agreed upon by the parties. So 11.2. A, party fails to act.
There's a failure of that procedure.
Then only we reach Your Lordship. So that does not take away 11.2. That confers an additional power
That point of view.
on the court. My Lord, page 69 and 70. Lord, I'm on the last point.
Yes.
My lord, last point, page 69 and 70, I have said that Singapore permits such a clause, asymmetrical clause. Britain permits such a clause, asymmetrical clause. But that again is not a decisive factor. The point is, whenever legislature wanted to restrict, it has done so by statute.
Ultimately, we have to construe our statute more than anything.
That's, my lord, the end of the matter. My
Thank
lord,
you.
last point,
Yes.
my lord, and I would, my lord, really oblige, my lord, if your lordships can consider this, my lord, this is directly linked with this. Please come to section 12. My lord, this is the provision, not a very popular thing to urge, but still, my lord, it is necessary, my lord, at times to urge, to ensure that the object is achieved. My lord, 11(1)(b).
B.
Sorry, 12(1)(b). And this is my last point, my lords. Your lordships, yawn is more vocal, my lord, than your lordships' words. But this is my last point, my lord, I can assure your lordships. When a person is approached in connection with his possible appointment as an arbitrator, he shall disclose in writing any circumstances, B, but I'm entering into a little unpopular area, which are likely to affect his ability to devote sufficient time to the arbitration, and in particular, his ability to complete the entire arbitration within a period of 12 months. Lord, this is observed in breach. My learned friend, my lord, says 100% breach. My lord, we are at item, my lord, Mr. Banerjee is also. So now, my lord, I am fortified by.
All provided.
Now, no, why I said,
Part 4 are notified. See, the solution to that is to have an arbitration council in
Council of
place.
India.
I'm,
The council in place, it will do all,
give me a minute.
all objectives.
Give me a minute more. Why I raise this in this matter? Lord, whenever there is a panel, and I'll give the list of panels, I don't wish to argue, just to illustrate. The panel gives the name of the arbitrator, other details, his qualifications, experience, etc., and the number of arbitrations that particular arbitrator is doing, so that the other party can choose that this arbitrator is doing 9 arbitrations. He may not be able to devote time to my problem, my dispute. So better I will go for some other arbitrator. My lord, I'll give that. Number 2, in ICC, whenever an arbitrator is approached, not only ICC, other institutions also, Lord, arbitrator is called upon to give his 2 years calendar. We have placed that on record. My lord, I'll give the page 1975. Lord, it is the list.
Mr. Solicitor,
I know it's not a,
what you are making is what we are saying.
Lord, what has happened is,
The spot has being responsible. Because specifically a 43D, we have provided the duties of the council, which will be to formulate timelines, to formulate accreditation, to call for information, how many arbitrations are pending before each. Put it up, all that on the website. Everybody will know how many arbitration each arbitrator holds. What is the timelines? These are the requirements. Now, all of these are ad hoc arbitrations. So even assuming that they are ad hoc, some institutionalization or some kind of a regulation must happen.
Lord,
That was the purpose and object of the council.
I always say,
What your concerns are reflected here under 43D, subsection 2 to
Correct.
K, L.
but my lord, B, 12A, 1B also says within 1 year. And there is thereafter 6 months extension, but 29A, my lord, I only on the lighter side say, my lord, before arbitrators, that arbitrators are now comparable. And it is on the lighter side, but nothing derogatory, with film stars in 2 ways. We always listen that we couldn't get the dates of this particular stars, therefore we have to appoint. My lord, it's very difficult to get dates. My learned friend would agree. Very difficult. Today's date will go after 3 months, 4 months. And second, film stars operate in 3 shifts. So do arbitrators. Morning shift, afternoon shift, and night shift. It's good, Malod. There's nothing wrong about it.
Did you say
But
3 shifts or 3 screens?
Malod, that is Malod.
Just,
I bow down. I bow down, Malod. I could say only 3 shifts, Malod.
I was not saying anything.
He was just wondering whether he heard screens or shifts.
Malod, the lawyers do that, Malod. That I can vouch for, Malod. We have been witnesses. Lawyers are hearing from more than one screen.
Unless we shift into this
Strict
now,
arbitration.
ad hoc arbitration is an unorganized sector.
It is.
It's an unorganized sector, there is no regulation.
Whenever, Malod,
So unless we shift into a situation
in
of.
institutional arbitration, this factor is considered. For example, Sarod, Malod, we have a Sarod arbitration. It is considered that this learned arbitrator has more than what can be done within 1.5 years. For 12 months, 6 months extension, but thereafter we survive on 29A. Court keeps on extending. And that's Malod, the hard reality, Malod, the ground reality. And Malod,
Why didn't you notify the, the provision and bring that into existence as an institution?
12(1)B says, Malod, that he has to disclose.
Answering that question with the
Why
Chief
is
Justice
the
asking.
government not notifying?
What's the concern?
Can be, Malod. I'll, Malod, consult the government and, Malod, it can be, should be notified.
Notify it immediately.
Certainly.
And you passed an act, right, for the other one? What is that act called?
That's part of this amended and included in this very chapter.
Malod, but
Headed by Justice Hemant Gupta.
Malod, would it still, Malod, I'm posing a question to myself, dilute 12(1)B, that you have to complete by 12 months, you have to disclose whether you will be able to complete within 12 months, and extendable period by consent is only 6 months. I leave it at that. Well, so far as, Malod, NBFCs are concerned, well, last point.
Mr. Solicitor, what we have done is my learned two judges, brothers, Justice Pardiwal and Justice Mishra, we must have appointed, I think, about 25, 30 young lawyers as arbitrators in this.
That's a better way. Malod, that's,
in the
but
smaller
otherwise,
claims,
Malod,
not necessarily smaller claims, but
no, certainly, Malod, my learned friend, Malod, but Malod, your lordship.
that's the Bombay High Court in winding up matters.
Yes.
Ultimately, it's not about winding up a company, small claims. By consent, we'd appoint arbitrators and not retired judges, we would appoint young lawyers, juniors at the bar who would be appointed.
And they are doing it very enthusiastically and within the time. But, Malod, I flagged it, Malod. I don't wish to be more unpopular on this argument, Malod. Therefore, I leave it at that. But 12(1)B is a mandate and there is no consequence of non-compliance with that mandate. Malod, so far as NBFCs are concerned, but there are certain institutions like railways, non-banking financial companies, where they deal with thousands of cases, thousands of arbitrations. Look, they will, by the very nature of their function, when I enter into an agreement for taking loan of, say, 2 lakhs or 3 lakhs, I know that there is a different bargaining power. They are taking a greater risk. Something which I cannot borrow from the bank is being borrowed from NBFCs. So I agree to a particular arbitrator. Otherwise also, Malod, take, for example, a person who has taken a loan of 3 lakhs. Malod, I'm posing a question to myself, do we really expect him to go in search of an arbitrator? He finds an arbitrator who is ready to work as per Schedule 4 fees, etc., and, Malod, deal with the NBFC.
Most of the smaller claims proceed ex parte, actually.
Yes, but
The lawyers appointed
to
by the
that,
bank.
Malod, there is a solution I am suggesting.
Credit card.
Malod, I have a solution, Malod, which I have placed on record. Malod, there is a solution on record. Malod, there is a page SAMA, Malod, it is called SAMA. One example, there is one example. There is an institution which does online dispute resolution. That's the best thing, Malod, for small, Malod. SAMA stands for Samjho Magar Pyar Se. That's Samjhao Magar Pyar Se. That's, forget the name, Malod. They could have chosen a better name. It's called SAMA. And, Malod, this is at page 1983, volume 5A. Lord, please come to only for a second. Lord, this may perhaps be a game changer. Kindly come to page 2000, my lord, volume 5A.
Correct. We'll go on
Only a minute, my lord. This may be a game changer. Your lordship would
Yes.
really contribute something, my lord, would be able to contribute something. Page 2000. My lord, this is one organization. Volume 5A, page 2000. It is recognized by the High Court, Government of Maharashtra, Bombay, Ministry of Justice, Union of India, etc. But its advisory council is former Chief Justice, Justice Sri Krishna, Justice Kannan, etc., etc. But this is online dispute resolution for small people. And the award comes within 45 days. Not expensive, no major, my lord, delays. I have placed, my lord, on record their entire activity. And this is recognized by many. Many banks have joined this for their small depositors or small problems. The loan agreements of smaller loanees, my lord, have a provision that dispute will be resolved by this. My lord, this, I think, is the solution for smaller depositors. We are not on big sharks, my lord, that's all. Obliged to, Lord. I'm grateful, my lord. I exceeded my time, my lord, but I'm grateful.
Now we go to Mr. K. M. Natraj. Yes, Mr. Natraj. Over and above what the solicitors argued, now what is the point that you are making?
Volume 5C, morning I forwarded my short written argument. So both on behalf of the court, that is the petitioner in the main matter which has been referred to the Honorable Court, and also I am representing IAC, that is Indian International Arbitration Center, which is an intervener. Representing both in the matter.
So what is the substance of it?
Yes.
You can just summarize.
Yes. May I kindly have my short written note, which is at volume 5C.
Yes.
So reflecting on the screen. I'll try to finish as early as possible without repeating any of the points which has been raised by learned solicitor.
Can you tell us?
Yeah,
I mean, just formulate what is.
Yes,
not
the first one is
argued.
the party autonomy, which is the basic feature of the arbitration, which for a different purpose I'm putting it, for the purpose of analyzing the very reference and the issue, which is the basic feature of the arbitration proceedings.
Your second bullet point is correct.
Yes,
That 7.6
yes.
arises only if any of the situations provided in A to
Correct.
C are not
Yes.
fulfilled.
Secondly, there is no statutory bar on either of the parties, either independently or jointly appointing an arbitrator. There is no statutory bar. Either of the parties can independently, one party can appoint an arbitrator, or jointly by virtue of some kind of agreement, jointly they can appoint. That is recognized and ingrained in section 11(2) of the Act, which is party autonomy.
Yes.
If that is the case, when there is a statutory bar, party autonomy has to be respected, and which is further fortified by section 11(6). Kindly take section 11(6), which again speaks of the agreed procedure.
What's the submission, Mr.?
Yes, under 11.6, it further fortifies the party autonomy for appointment to evolve any kind of procedure to be adopted by the parties, either individually or independently. And again, section 12 also recognizes and fortifies such a right.
Yes.
By keeping in mind, two things will have to be considered. One is both appointing authority or appointing person and the arbitrator are two independent and distinct entities. And their identity is different. Appointing and acting are two distinct roles.
All right. Next, what is the next one?
They are distinct roles. If they are distinct roles, the statutory prohibition is only for the purpose of the acting as an arbitrator, not for the purpose of appointing. The law does not prohibit any kind of restriction insofar as appointing authority is concerned.
Yes, next.
The appointing authority can appoint, and the impartiality or the neutralities that is attributable only to the arbitrator appointed and acting as an arbitrator.
All right. What is the next one?
If that is so, now what is not provided under the statute that need not be read into,
No limitation.
no limitation
Yes.
prescribed under the Act.
No limitation can be written by implicit.
Yes. And the omissions, even if it is an omission, that cannot be supplied by interpretation.
All right. Anything else?
Sir, in support of that, 4 judgments I have also placed, including the wisdom of the legislature, upon which once there is no embargo on the person who can appoint, then there is nothing more to be said about it. And 2 things in TRF, the situation was totally different. TRF, that the arbitrator himself was the managing director himself was an arbitrator, and also he was supposed to appoint. In that context, it was said so in the TRF case. And here in the second, this reference by Justice Nariman and the 3 judges bench in Tantia, kindly see that reference itself is a totally, may not be appropriate, this one, reference. Kindly see how it has been referred in this one, in volume 1, page number 3. It presupposes something which is not otherwise provided under the Act. Kindly have your reference at page number 3.
Volume 1, page 3.
Yes. eligibility, everything is on the arbitrators, not on the appointing authority. So therefore, there is nothing to read something relatable to the appointing authority. I'll leave, please.
Natraj. Now we will hear Mr. Arvind Kamath.
All right.
Mr. Kamath, apart from what has been argued, what would you like to say?
Yes, my lord. I represent the BMRCL, which is the Bangalore Metro Rail Corporation. But I'm purely on the issue of the maintenance of the panel system. Now, I've got
The maintenance of
the panel by one party.
Right.
Purely on that issue. Lord, I've got 5 propositions stroke principles to be placed before
Just
Lordship.
tell us, formulate.
And Lord, the first one is that the contractual conferment of a right to form a panel of arbitrators is a commercial bargain.
One second.
But I'm saying the contractual confirmation of a right to form a panel of arbitrators is a commercial bargain, and it falls within the purview of party autonomy under Section 11(2) of the Arbitration and Conciliation Act. Lord, every commercial contract is a result of a commercial bargain. Lord, parties are free to bargain their rights, provided it is consistent with law and public policy.
What is the second point?
The second point, my lord, is that enlisting of the names on a panel does not per se constitute appointment. Lord, I enlist the names only for the purpose of administrative exercise. My lord, merely because I add the names on the list of potential arbitrators, there is no conferment of any rights, nor does it entail any remuneration. It does not even guarantee a right to be appointed.
Got the point.
It is only obtaining prior consent.
Third point, Mr.
My lord, the third point would be that, my lord, yesterday we saw the perception-based challenge to the procedure of appointment is not sustainable in law.
One second.
Lord, every strand of argument
Just 1 second. Perception-based challenge.
to the procedure of appointment of arbitrators from a panel maintained by one party is not sustainable.
Panel.
Lord,
One
perception.
second. From a panel maintained by one party. By one party, what? Is not sustainable.
Is not sustainable. My lord, yesterday we saw, my lord, argument like, for instance, there is an economic incentive to pass an award in favor of the party who maintains. My lord, it is based on perception. My lord, the allegation that I curate a list, my lord, is based on perception.
Fair enough. What is the fourth point?
Lord, the fourth point would be that there are statutory safeguards to ensure independence and impartiality of the impaneled arbitrators. And it's a 4-tier, the statute has laid down a 4-tier mechanism. And those 4 are, Lord, I'll quickly enlist the 4. Lord, number 1 is the insertion of section 12(5) as well as schedule 5 and 7.
Yes.
Lord, number 2 is the mandatory declaration, Lord, which is a consentious declaration. It is akin to an oath by a judge.
Mandatory disclosure.
Mandatory disclosure under
Right.
section 12.
Third?
Lord, the third is, Lord, the statute provides a challenge. Just in case, Lord, an unconscientious decision is made by the arbitrator, it gives a right to the party to challenge him.
Okay, that's the
And Lord, fourth is that if there is a challenge made and if it is declined, that gives a ground to challenge the arbitral award. So which means there is a judicial review of the decision of the arbitrator that there is no bias.
Yeah.
And both those arbitrators appoint the presiding arbitrator. So which means it's a very fair principle.
Thank you.
Therefore, not I'm breaking down, Lord, the formation of the panel should be divested from the way the panel operates. The formation of the panel, my lord, it's a contractual right. But how the panel operates, my lord, Voestalpine has laid down the principles. So therefore, my lord, to summarize, maintenance of a panel by one party is not following on the sole ground that Tantia doubted core. Not the learned single judge should not have, learned single judge should have followed core.
Well, thank you.
I'm grateful.
You've rendered very valuable assistance, very well formulated.
I'm grateful, Raj. I'm
Thank you,
grateful.
Astra. Yes, now, 1 second. Now, we will, Mr. Guru Krishna Kumar.
I'm in 501.4, my lord.
Yes, Guru. What's the formulation?
My lords, broadly, four points, my lords. In fact, my submissions, I'll put it as propositions and leave it at that, my lords.
Number one.
One, while adopting, my lords, the submission on behalf of the Solicitor, by the Solicitor General, my lords, that the statute per se does not bar unilateral appointment of arbitrators. I adopt that. While adopting that, I want to make this formulation. The exercise of power under section 11(2) of the Act, my lords,
One second.
is conditioned by section 12 of the Act. Because the language used in 12 is anybody invested with the authority to appoint before the appointment has to get declaration from the prospective candidate. Which means, therefore, my lords, please see the language for a minute, my lords. Just have a look at that. Please see 12. When a person is approached in connection with his possible appointment as an arbitrator, he shall disclose in writing any circumstances, then A, B, etc. Then please see the second explanation to 12, my lords. 12 after B. The disclosure shall be made by such person in the form specified in the 6th schedule.
All right.
So this is one. Therefore, bodily, my lords, 12 and Schedule 5 and Schedule 7 have to be read into 11(2). That's one, my lords.
Yes, yes.
Second point, my lords. Mutuality, which seems to be the premise on which, my lords, there is reliance on 18. There are three.
Mutuality.
Mutuality is the premise on which, my lords, section 18 is being invoked and sought to be read into the appointment process. Now, for that, I have three submissions, my lords. Number one, that does not take note of the fact that 18 is a general provision in the next chapter, whereas 11 is a provision specifically for appointment. And the legislature has consciously, my lords, not brought in that principle in 11.
Next.
Third point, my lord, assuming 18 can be invoked by some basis, mutuality will have to be understood, my lords, in the business setting and the fact setting of the parties' transactions. Arbitration, my lords, is at the end of the day a consensual arrangement for adjudication of disputes other than through the court process. Therefore, the business setting and the background of the transactions will have to be understood. There cannot be an omnibus stand that unilateral appointments cannot be resorted to at all. And to contextualize this submission, my lords, I want to talk about my NBFCs. The Solicitor General referred to it in the passing. I am representing an NBFC. I have a claim for a few lakhs of rupees. In fact, in this very case,
Yes.
the party does not respond to the notice for appointment. I go ahead, appoint the arbitrator, award is granted. The award is sought to be executed by me. At that stage, Perkins is taken note of by the execution by court by itself, and, my lords, the award is held to be a nullity, and the whole thing is set aside. I've come against that, my lords.
All right.
Now, therefore, this is the second point, my lords. Business setting has to be understood. In fact, the fact that business setting is a factor in the legislation, please.
All right,
Take a note.
1 minute. Huh?
Uh,
You
one-
have to wrap up. Yes, you have to complete the
There, my
others.
lords,
Next.
the next point is, my lords, the nature of, my lords, the transaction and business setting. It is given importance, my lords, in the statute itself. For that, just please make a note of explanation 2, schedule 7 and 5. Just have a look at that. Please see explanation 3. I'll just read that, my lords. For the removal of doubts, it is clarified that it may be the practice in certain kinds of arbitration, such as maritime or commodities arbitration, to draw arbitrators from a small specialized pool. Now, one thing, I'm reading from the explanation, my lords, to schedule 7, and it's there in schedule 5 also.
Schedules explanation.
Yeah, schedules explanation. Both schedule 5 and schedule 7, my lord. Explanation 3 in both.
Practice in certain specific maritime or commodity.
Yeah, such as maritime, and therefore, the nature of the business setting, my lords, becomes material, even statutorily recognized.
Right.
The last point is this, my lords. What is the alternative, my lords, that they are talking about? The entirety of the submission is on a perceived apprehension of bias. The entirety of the submission, it's on a supposition that unilateral appointment necessarily is not fair. Law cannot countenance that. In fact, my lords, the alternative of institutional recourse. Number 1, my lords, lack of institutions. Number 2, metros versus non-metros, my lords, where is the access to institutions of that nature? We are looking at small loans across the spectrum, my lords, MSMEs, consumer durable loans, all of that. I have today, my lords, 6,000 arbitration awards in my favor. And I have 10,000 cases every month or something of that order. Third aspect, my lords, if we have to take recourse to court, please see the burden it will add to the court system.
Thank you.
These are the points, my lords.
Thank you. Thank you.
Yeah.
Now we'll hear Ms. Madhi Devan.
One last thing, my lords, my apology. Alternate submission. In case my lords were to countenance Perkins, please, my lords, look at prospective overruling. In case my lords are
I
concerned.
didn't address that, but that is going to be a very vexed question, my lord.
Yes.
Whichever way your lordship decides, whether it would have prospectivity or retrospectivity, because in some cases arbitrations are going on, some cases 34 is going on.
So many thousands of awards.
7 is going on. In fact, Mr. Shashank Garg wanted to Lord, have few minutes, if your lordships can permit, my lord, on only prospectivity.
In fact,
But
That's an alternate submission.
that's an alternate submission. My submissions, my lords, in volume 5, I've covered that also, my lords. My lords can have a look at that, my lords. Page 277, my lords. My submissions are there, my lords. I'm deeply obliged.
Yes.
Yeah, that's it.
Yes, Ms. Madhi Devan.
Yes, my lords. I appear also for an NBFC, and my issue is of unilateral appointment. My lord, the points I will make is 1, my lord, this is a very comprehensively crafted scheme by the legislature under 12, 13, and 14, which has been ignored by the court, my lords, in Perkins and even before that in TRF. And I'm going to, my lords, show your lordships the devastating impact of not taking into account this comprehensive scheme, which creates 2 categories of clouds on integrity, on independence and impartiality. There are 2 categories, and perhaps, my lord, this has not come up in the arguments this far. So I'm just spending, my lord, a couple of minutes on this. There are 2 categories. One is what is described as the non-negotiable category, which appears in 12.5, read with the 7th schedule. Other than, my lords, the proviso over there, it is an absolute bar of ineligibility. 7th schedule based on red list, best international practices, very intricately carved out bar of rank ineligibility at the very threshold. Now, when it comes to this rank threshold ineligibility, the effect is the arbitrator, my lord, the appointment is void at the threshold, there's cessation, and the procedure is that you go under 14.2 for termination and substitution. So it's a different procedure when in category 1, I'm describing it as category 1, threshold ineligibility under 7th schedule, resulting under 14.2 in termination and substitution. Now, my lords, mine is not a category. Unilateral appointment is definitely not barred there, definitely not. And therefore, applying the principle of, my lord, expressio unius, my lords, I won't get, but basically the expression of one means the exclusion of the other. My lord, this was all expressio unius, exclusio alterius. So that is the principle. And insofar as I am concerned, my lords, please see, it doesn't fall within that. And these schedules, the two schedules and the other one I haven't yet referred to, the two schedules were brought in by this amendment in 2015. Before that, everything was left to a little bit of vagueness, but now that there is this schedule, you have to follow it. The court could not have added to this either in Perkins or in my lord TRF to start with. They could not have added to this, and they did not consider the devastating impact, which I'm going to point out, my lords, which it is having. Now, that is category 1. Category 2, my lords, shows that even, my lord, in cases like mine, if the other side is aggrieved, they have a remedy. They have a remedy. That category 2, my lords, falls into cases which are under the 5th schedule. So other than the non-negotiable variety under 12.5 7th schedule, you may also challenge if you feel there are justifiable reasons for challenging the appointment of the arbitrator, which may fall within 5th schedule. And mind you, my lords, I must point out, the 5th schedule is only a guide. The language of section, I mean, my lord, to save time, I'm not referring to it, but please note the word used, it's to serve as a guide. 5th schedule is a guide, but 7th schedule is exhaustive. So if you apply that, my lords, even a unilateral appointment, perhaps you can challenge, but it's not rank ineligibility at the threshold. That's the distinction I'm making, my lords. So what Perkins and TRF do is they knock them out at the threshold saying you are ineligible. That cannot work. That's not correct. What happens in the second category? I'm sorry. My lord, what happens in the second category of cases that if you are aggrieved by some justifiable ground, which may fall within Schedule 5, it may be a little bit beyond Schedule 5, but you may be guided by it. Then, my lord, the procedure is different. It falls under Section 13. You go before the arbitrator and challenge it. You go before the arbitrator, and if you are not successful, the award is passed by the arbitrator, and then you may challenge it on that ground inter alia under 34. And then the court decides whether he gets his fees or not, if you are successful. So, my lord, there are two different parallel things, two categories, different procedures which are prescribed with different consequences, but unilateral appointment may fall within the second category, but it certainly does not make my arbitrator ineligible. Now, the reality of our situation is that My lord, the reality of our situation is our, my lord, other side does not, in 95% of the cases, doesn't even show up at the notice or the arbitration. So if he has the opportunity to challenge if he wishes to, saying that this is unilateral and it is therefore not impartial, etc., but he has not done so. So by the court in this case, my lord, and that's the impugned order, the court helping him out and setting aside the award effectively on the ground that this is violative of Perkins means what, my lord? Ultimately, it's a defaulter's paradise. It is giving him an incentive to walk away. He is not wanting to challenge it. He is not coming over there, and yet we are creating a situation of a defaulter's paradise. So, my lord, now please see, my lord, this my second point that I wish to make here is that both Perkins and TRF, my lords, are, with great respect, they are oblivious to not only this comprehensive scheme in the Act, which takes care of every eventuality, but also the specific SOR which accompanied the 2015 amendment, specific SOR, and the business realities of the situation. And when I say business realities, I don't only mean business prudence. I mean, my lords, today, for example, my lords, I have awards worth, my lords, 22,000 crores in excess. They are at the stage of execution. Some of those awards have been knocked out on the ground of Perkins. That is the devastating impact it is having when the other side has not even shown up to challenge it. Now, my lord, even though every year I, as Mahindra and Mahindra, I dole out, and my lord, this is for vehicle financing. So these are small people who get loans to get taxis, trucks, auto rickshaws, etc. So it's livelihoods. There is employment being generated and families are looked after through these livelihoods. What happens in the process is that, my lords, if my today 22,000 crores because of Perkins and the other judgment, my lord, TRF, I'm not able to execute those awards and they will be knocked out, as some of my awards have already been knocked out at the stage of execution. What happens is this money is stuck in the economy. I'm not able to recover. I'm sorry?
Again, awards become bad. These are
because of Perkins, because, my lords, what they say, because of Perkins, these arbitrators are ineligible, unilateral appointments, because, my lords, please see, very interesting. I'm grateful. Why? This is what has happened. Please see, my lords, in Perkins, that principle of TRF is taken.
Have been set aside on the ground of Perkins.
Yes, yes, in my case, hundreds and hundreds of awards at the stage of execution.
So you appointed your arbitrator directly, what happened?
Well, we appointed, they never challenged the other side.
No, most of them are all ex-parte awards, is it?
Yeah, ex-parte.
Okay, you appointed an arbitrator
Yes.
on the basis of your panel, and he's proceeded to give an award. And those were set aside by the courts under 34 on the ground that it is hit by Perkins.
34, they never came. At the stage of, when I went to execute,
It's all.
it was set aside.
Yeah, naturally.
But did you appoint your arbitrator under, by moving the court under 11, or you just unilaterally appoint?
No, that's my agreement. I appointed in accordance with my agreement, point number one.
So what you do is that you say, well, I'm appointing an arbitrator.
Lords, please see, it is, he is noticed, well, just 1 minute.
That doesn't matter. The principle, what we are concerned is the way we should interpret.
That's right. Whether
the panel.
panel.
Your cases are all standalone cases where at the time of execution, the courts have said the review of Perkins awards are set aside. So stand on a different footing.
Lord, unseat trial must have a limit. No. Not relevant. My lord, I am saying this, how can Perkins apply if I'm not in that red list? I'm
Company?
Mahindra and Mahindra, but there are many others.
Because there are 5 lakh
Whom do you appoint as arbitrators, buddy?
Advocates, all advocates. And nobody has said that they are, my lord.
All right, this is
All
not
right.
so much.
See,
We'll not go into the individual
This is
side. We
slightly
know what's
different.
happening here, but
my lord, please see how either I fall within, my lord, 12.5. I have to fall within 12.5 and the 7th schedule. Where do I fall within that? I don't. That's my point.
you are on the basis point. We are only going to interpret.
Now, please see the practical reality, and because ultimately you're in NN Global, Shiv Shakti, my lords, all those judgments your lordships have said. So therefore, I'm saying they have an opportunity if they are unhappy, and we wrote to them saying we are appointing so and so. If you have an objection, please respond. They don't respond. They don't respond. And where do I go, my lords? Companies like us,
But your arbitration agreements provide for a sole arbitrator to be appointed by you.
Yes, they do. And then, no, it's not proscribed.
All right, we'll not go into this actually. This we need not go into. So essentially, the arbitration takes place by a sole arbitrator appointed by the financier.
See, what is the alternative? I go under section 11. Just please consider. There is no provision.
No, you can't go under section 11.
Exactly.
Because that's a 11-2 procedure.
Large number of section 11s have been filed by finance companies, insurance companies after clearer. Independent arbitrators have been appointed by high courts. There is an ADRS monod platform. The learned Solicitor General also provided another independent platform. The sort of
There is
not the Miss Diwan, the point is only this. Can there be a unilateral clause by virtue of which, look, I will appoint an arbitrator. You may be I'm a finance company. I will appoint an arbitrator. I will appoint a lawyer who will be an arbitrator. The matter will proceed ex parte. And some poor taxi driver, truck driver, his truck will be dispossessed. Yeah. Poor truck drivers, he will be thrown out by a bunch of goons who will sort of catch him on a national highway, throw him out in the middle of the night, take his truck and say, we have the award for 20 lakhs against you. That's what's happening. That's the reality. That's the reality.
Mr. Paul, please allow.
That's the reality. Yeah,
No, my lords, please see this point. I cannot engage.
Don't take it to that extreme, it might be counterproductive to you, to your argument. So far as the interpretation of the larger principles, if we are thinking about it, that you make a submission. Don't go into this devastating effect and all that is irrelevant. On the interpretation of your clause, say,
This is actually putting arbitration on its head. It's providing arbitration a bad name. You've dealt with n number of cases in the Bombay High Court, I can tell you, where, less said the better how it is done.
What is my alternative but to have, if he is not even coming, if he were to come and cooperate?
A poor taxi driver, a truck driver, a two-wheeler driver in Kolhapur or some other guy go and contest it against Mahindra. That's a hard reality.
56,000. Now, if we opt out, what is the option? We can't go through goons. We can't file a suit.
That's the kind of things they're doing. Each of those arbitrators, I didn't want to get into the merits of my learned friend. 400 arbitrations per week per arbitrator. So-called appointed independent arbitrators unilaterally.
How do I go ultimately? My lord, we are providing, banks will not entertain these taxi drivers. I am entertaining them. We are all providing loans to them and we are not doing favors. If we get back our money, we can finance more. We are providing a service. Lord, government's mantra is ease of doing business, provide employment. This is happening through us. How do we recover our money? We are giving money.
Sorry, but Perkins is a sole arbitrator case that may perhaps not arise. These issues, here your lordships are deciding whether a panel is permissible. Perkins was, my lord, we generally forget, my lord, while citing, it was a sole arbitrator.
So, Lord, my case is also of a sole arbitrator, which is why I'm concerned. If I don't fall in the red list, if I don't fall in the 7th schedule, how can I be knocked out on the ground of eligibility?
Originally, if parties agree that there will be a sole arbitrator appointed by consent, the other side doesn't consent, you have to move the High Court under 11. High Court will ensure that a genuinely independent.
Not consented, he receives the.
Did you ask them for consent?
Yes, when I appoint the arbitrator, I ask him.
But there's under the execution.
We put all.
Those matters will be dealt with independently.
Since I'm
Because of Perkins, my lord. Your lordships, if your lordships are going to pronounce on, ultimately it will boil down to Perkins. Even in the panel matter, it will come to Perkins. Who is incapacitated? Who is incapacitated? That begs the question. My lord,
then your lordships will consider detagging this matter because
my lord, I wrote to him. If you have any objection, please show me. Yes.
sorry for
My letter. My lord, my letter to him asking if he is objecting is on record.
Issue, we are saying the power to appoint even the procedure. We are just upper to a point.
My lord,
Lord, this NBFCs stand on a different footing. They have different fact situation, different arbitration clauses. They are not concerned with panel. Kindly detag it. My lord, it need not be dealt with by the Constitution.
Unfortunately,
And whatever judgment comes, my lord, whether they help them, whether they.
I'll tell you one thing, speaking for myself as single judge, division bench, I've seen what happens when unilateral appointments of arbitrators are done. Literally, you can hold,
Lord,
I'm not saying
Lord,
that.
we
I'm not saying
have
that
done our best, my lord.
defaulters-
It may
that
not
the
go in
defaulters
this.
are necessarily, but most of the defaulters are individuals, sole people, somebody's auto rickshaw, somebody.
Lord, let Madhvi, can I say something? You already.
The procedure for arbitration, the procedure of arbitration is perverted by this.
My lord, kindly deal, my lord, NBFC issues separately. My lord, your lordships are dealing with the scheme of the act.
No, we don't think we
Permiss-
need to do that. We will answer this, the difference.
Lords, I'll tell you, Lordships, because I have
We
five
would
lakh
not like,
arbitration
Lord,
scores.
our larger issues to be, Lord, colored at the end by this, Lord. That's-
I represent a body, Lords, which has
Cannot
5
pick up
lakh.
those cases, you must challenge it.
Lords, so that's.
Challenge it. That's it, that is those individual cases, we will see, if you might succeed.
Lords, but 5 lakh arbitrations are, Lords, now under effect.
No power. Still, no.
Done is
There's no power because in
appoint an arbitrator, how am I barred? Is a party barred? Is a party barred from appointing? There is no such bar in the very intricately crafted act and schedules.
All right, we will consider.
Please consider that, my lords, and ultimately, nobody is
Alright.
giving these people
Then,
notice.
Mr.
My
Anand
lord,
Padmanabhan.
I have my own submissions, my lord. I would not endorse any of these submissions, my lord, but because they have a fact specific case, that's all.
Sir, may I put in a written note?
Mr. Anand Padmanabhan is there.
Lord, I'll take 3 minutes by the clock.
3 minutes. Then we have, after Anand Padmanabhan is the last for the petitioners. Then we have Mr. Jetmalani, then Mr. Napil Diwan, Dinesh, Munkund, Suman Doval, and Naresh Kaushik.
Because I have also, because I have also filed.
Let's.
Well, but we'll assemble tomorrow at 2 o'clock because instead of. But we'll have to complete by 3, huh?
I think.
Not 2 to 4. But a miscellaneous day, I may have to go back to my regular bench. So we'll say 2 o'clock, we'll take this between 2 and 3, not beyond 3 o'clock. So
My lords, between us are 7 minutes each.
But I will do it in 5 minutes. I don't need more. than
That's
5.
all for us, my lords.
My lordship,
also, we'll just look at quickly the reference by Justice Nariman.
Yes, yes.
That one para order,
There
which
is-
really doubts 4.
Yes, that's doubt score, and in JSW, because the Karnataka High Court relied on core, they refer it also to the Constitution bench.
Nobody's doubting.
Core was doubted in Tantia, and in JSW, there was a completely different clause. The High Court said, the MD in the case said, I'm appointing as per core, ignoring the arbitration clause. And the High Court says core is said so what's wrong with it?
Lordship, I had a small request to make, Lordship, I had a small request to make today in the alternate bench. Item 1 is the jet insolvency matter. If it can kindly retain its position.
Constitution bench, how can you pass?
My apologies, my apologies.
But wait, I'll talk to the registrar.
Deeply obliged, Lordships, deeply obliged.
Chali.